Appeal part heard in the matter of Michael O'Hagan, FX Class Representatives Limited, and Evans and others.
Yes.
Good morning, my lords. I was coming towards the end of my submissions on the strength factor in the Tribunal's application of Rule 79.3. We were in the judgment, and I was coming to the very end of my analysis of the reasoning in the judgment on this strength factor. Page 376 now, please. Yeah. Page 376, paragraph 241, sub 1. Where the Tribunal, having analysed the various factors that I've already taken you to, say we simply do not understand how these applications could properly be tried. The pleadings give no idea as to how the losses claimed have been suffered. And when they say pleadings, again, as I've said, I think they're using that as a shorthand for the pleadings and the expert evidence that they've considered, as to how these losses claimed have been suffered. And we do not consider that this tribunal can effectively manage these cases to trial or at trial, nor do we consider that respondents can properly defend themselves in circumstances where, although the nature of the claims are understood at a theoretical level, there is in reality no pleaded case on causation. And again, I have to say, they must mean a case by reference to the pleadings and the expert evidence, because that's what leads them to go on to find, as you've already seen, that the cases are intrinsically weak, even if pleaded, the cases are on their substance intrinsically weak. And you saw that in paragraph 375 of the judgment. The cases were intrinsically weak in both senses. My learner friends took you to that paragraph. And in my submission, the approach of the tribunal
if the disclosure provided by the defendant banks in due course demonstrates that over the cartel period, the customers of the banks, the claimants, were consistently overcharged in FX trading, then where's the problem? On the basis of the Evans, the Evans class representative, Class A. I mean, we follow from what you argued yesterday. There are issues about Class B, which are more acute than Class A. Speaking for myself, I can't see how the tribunal couldn't try it. It seems perfectly straightforward.
Well, that's what...
Just not at that stage, and that's the whole point. They're not supposed to say, oh, well, this can't be tried, because this is a certification stage. This is the same error as the court fell into in the Brazilian dam case. This is also frightfully complicated. We can't try it. We can't case manage it. We can't try it. Therefore, in that case, it was struck out as an abusive process. And the Court of Appeal said, no, that's not appropriate.
My Lord, on that point...
When I read this, I immediately thought of what Mr. Justice Turner had said in the Brazilian dam case. I thought that's pretty wrong.
Well, may I seek to...
No, there's no reason why you shouldn't try. I'm just telling you what I'm thinking.
No,
by the end of the day, you may have talked us around.
Well, I'm really grateful for the indication, because I will try and talk you around on that Class A
sure
point.
You will, Mr.
But I'm trying... Well, it's actually a very...
That's a compliment, by the way.
I know. I'll take any compliments I can get.
Touche.
On Class A, though, I think there is a short answer to it, why the tribunal was right to say that it was intrinsically weak as well. And it's this. The Class A claim depends on showing that the spreads were widened for the customers of the respondent banks only, that the non-respondent banks did not widen their spreads. Remember, Class A seeks to show loss and damage based only on the widening of spreads by the respondent banks to their customers. But obviously, if the respondent banks widen their spreads uncompetitively in this way, they would, we would say, obviously, be immediately undercut and beaten by the non-respondent banks, which, on the Class A case theory, have not widened their spreads.
Doesn't that run rather contrary to your argument about Class B, which is that the market is not transparent and people don't know? Why would they know sufficiently to then react and undercut?
Because
On your theory.
there may be a tension between them, my lord, but the basic point is that this is the whole of the market we're looking at. So the Class A theory is that all the respondent banks are widening their spreads generally towards the general customer-facing segment. And then, and they may, let's presume for a moment they do that initially.
Well, hang on a moment. I mean, I follow the point, but the Evans case is, the case theory is that they were all widening their spreads. So they simply divided up the claimants into two classes, direct harm and indirect harm. But the Class A class isn't a class which is, for which the case theory, as I understand it, is exclusively the respondent banks are widening their spreads. It's part of an overall case that they were all doing it. I think that's right. That's my understanding.
The problem with that, my lord, the problem with that is that
Well, the problem
is that you still need to show the non-respondent banks are widening their spreads.
Yeah,
So
I know.
you're trying to
follow.
divvy up Class A,
Yeah.
but for Class A
I mean,
to
in
work,
a sense, you would say, well, that demonstrates that the whole case is weak, because if Class B is weak, then it infects Class A as well.
exactly.
So
That's the point.
I'm not, I'm just wondering, why is it an essential part of the Class A case to show that the Class B claims are strong as well? The other way around.
No, the Class A case theory does not engage with what the non-respondent banks were doing. But my point is that the reason why looking at Class A in isolation doesn't work, because if they widen their spreads, the respondent banks towards their own customers on a market-wide basis consistently, the non-respondent banks would logically.
Well, this is the point we debated this
Yes.
point yesterday. But that sorry, it's not part of the Class A claim. Class A claim is not dependent upon showing that the non-respondent banks widened their spreads. You're just saying you can tell that the Class A claim is weak because logically what should have happened is that they would be undercut by the non-respondent banks, and that isn't what is alleged in relation to Class B. So you're pointing out the illogicality, as you would say, the Class A claim.
Yes.
By reference to the way that the Class B claim is put. But there are other reasons that my Lord, for example, has just indicated why the Class B claim may be weak, in the sense that there may be other reasons why the non-respondent banks didn't undercut. Lack of transparency in the market is one of them. Isn't that all a question for trial and expert evidence? Unless you can say that the bit of the expert evidence, the pleadings in the extended sense, where this is addressed by the claimant's experts, i.e. the infection of the respondent banks by the activities of the limited number of dealers, unless you can say that's just not arguable, to the it's just implausible, it's just not sustainable. Now you can see that. Unless you can surmount that obstacle, the Class A claim doesn't have the same objections, most of which, as I read the CAT's judgment, are focused on the market effect, the Class B claim, as we've been terming it.
So, Madam, may I take that in stages?
Yeah, sorry, there's a lot of stuff in
No,
there.
no, no,
Sorry.
but the first is that I accept that I do have to say that this is not a question for trial, that it was open to the tribunal to find, based on the evidence before it, that the case was intrinsically weak, and obviously so at this stage, and it could make that judgment now and not leave it for trial. And
You've only got, we've been asking ourselves, what is the point of law in this? I don't, what's the point? We're obviously grappling with the economics, we're trying to understand it, but at the end of the day, we have to stand back and say, how does this translate into a point of law? Your argument is no more than the CAT was acting within the scope of its discretion to make the finding it did, notwithstanding any of the
inconsistencies of language and so on and so forth, which we have to address. But you're simply saying they acted within the scope of their discretion.
Yes, my lord.
That's the only point, isn't it?
It is, and that's why it's really important, tempting though it might be. One's intellectual curiosity is fizzing and one wants to get involved and take a different decision, but they have to identify an error of law, and this is a broad discretion. This court has said that under Rule 79.3 it's a broad discretion. That's what the court said in Patterell. It's very multifactorial. And
we've also said, I mean, we've had to grapple in other cases, and as we discover from case to case, the permutations of fact which arise are quite different from one case to another. So we've got to move with a degree of caution, but we also have to work out where the line is beyond which the CAT should say there is enough for this to go to trial, recalling that it has the protective mechanism of the respondent coming back on a strikeout later. It's never without that weapon and that safeguard. So where is the line? And we try to work on this point in both Goodman and in the Patterell. Where is the line? And the question is, has the CAT in this novel, difficult, complex case, has it gone beyond that proper line and really done too much at the certification stage? And
in circumstances where this was effectively the first case. I mean, it wasn't in the sense that Merrick's was earlier, but because the CAT didn't certify Merrick's. So this, I think, was the first case, the first big case where there was certification.
yes,
And
with
it
this
came
opt-in, opt-out debate.
before the Court of Appeal judgments in Le Patterell and Goodman.
That's correct, my lord.
And so, on one view, where the CAT has gone wrong is in not applying the test that we laid down in those cases.
Well, I'll come back to that, because in my submission, plainly, if the CAT has acted contrary to the test that you set in those cases, that is an error of law, and that's important. But what we're discussing now is really different. It is the multifactorial assessment, and unless the tribunal has been plainly wrong in what it's done, it's not for you, even if
we accept that there is a broad discretion for the CAT, and we also accept that in a novel case they may justifiably go beyond that which they would do in another case. But they drew themselves the distinction between Merrick's and a straightforward pass-on case, in a consumer case, and the present case. But in the Patterell, we effectively said you've got to have a plausible theory. That's at least the bare minimum. And then there's to be something else. And you've either got evidence, or in a case where asymmetrical information barriers are high, you've got to be identifying the sort of evidence that you might possibly realistically obtain on disclosure to explain how that might take you forward. And you may then have to draw stumps, always with the protection that at a later point in time people can come back and apply a strikeout if it turns out that the Leviathan has been let loose for no good reason. So, we're grappling with this. The CAT has said there's a plausible economic theory. And the question is, what is that additional ingredient necessary to get the CAT over the line, at least at this point, subject to a future strikeout?
May I address? Yes, my lord, to the extent that. May I tie that into the points I'm going to make to respond to?
Yeah.
Sorry, my lord.
Sorry. Anyway, we'll let you. We said we weren't going to interrupt you today.
No, it helps me to know.
I think technically we didn't, because we didn't actually give you a chance to get going in the first.
Really, we appreciate what's happening, and we need to understand the position. But my lord, there were three points I wanted to make to your point, which was, I made the first, which was, I don't shy away from saying that yes, for the tribunal judgment to be upheld, you have to agree that they were entitled to say that it was so weak at this stage that they could refuse. In relation to Class A in particular, that Class A theory doesn't work. If you look at it in isolation, also intrinsically weak, because in reality it depends on the non-respondent banks also widening their spreads. Subject to this extra transparency point, which my lord mentioned and that my lord Justice Green raised. But one must distinguish between the transparency between the banks, what they can see, and the customers. So the PCR's evidence, and we accept, is that customers do shop around. And these customers, the class members in this case, are not going into bureau de change, they're not SMEs or consumers. These are financial institutions themselves or import-export businesses that use FX dealers, and they, the PCR say, shop around, and they would see on a market-wide basis if 20 or 30% of the banks were consistently charging wide spreads and 70% or 60% were charging more attractive spreads.
Don't do it now because it will spoil the flow, but my recollection from the evidence I saw was that the market was not as transparent as, for example, the equity markets.
That is, I drew your attention to that evidence, and that's exactly, that's exactly what it said. But and it's a matter of dispute as to how much shopping around customers do.
And how transparent the market is.
Yes, but it's important on transparency to understand what the banks can see and what the customers can see. But it's true that there's less transparency even for customers than in the equity markets. I drew your attention to that point myself. But the tribunal, in assessing this, addressed this very question, again a question of fact. To what extent would customers, because I took you to the bits where the tribunal said, this is a reasonably competitive market. There is a homogeneous product. There's a huge amount of flow. It's a massive market. Customers can, and in many cases do, shop around. And if you're asking how they can improve market-wide harm, the tribunal took a view as to the impact of intra-market competition. And that's what troubled the tribunal so much, because they struggled to see how the applicants were going to get over that hurdle. They couldn't see a plausible case on the applicant side that would answer the point that I'm putting to you. And that was a factual assessment that the tribunal took. That was the third of my 3 points. And none of that's inconsistent with the analysis in Le Patuel, which my lord put to me a moment ago. And I will take you to Le Patuel when I come on to practicability. So the short point here is that the tribunal was really concerned with the lack of methodology, although it didn't use that word. And for that, I want to take you briefly to Gutman in this court, just to touch on, and you'll see an echo of the language the tribunal was using with what this court used in Gutman. And it's in the 5th volume of Authorities.
Yeah. It's tab 48.
Tab 48, indeed. Page 1479. And paragraph 54 is the paragraph, but the bit that I want to show you is over the page on 1479. The court's very familiar with this. I'll take it quickly. The Microsoft test, the idea of what kind of methodology is required, accepts that it would be hypothetical. It will use assumptions and regression analysis. It's not a fair criticism to say that it's hypothetical, although equally the tribunal will expect to see some factual basis for the assumptions and models deployed, hence also the reference in Microsoft to the methodology not being purely theoretical or hypothetical. And to carry on in that vein, if you carry on down that page to paragraph 57, intuition.
5 is important with respect.
Absolutely.
5 was the point that I was putting to you a moment ago.
And I don't deny for a moment, my lord, and I said it yesterday, that if the applicants could show that the problems with their case, the things that render it intrinsically weak, could plausibly be fixed by disclosure from the respondent banks, I'd be having a very different discussion. I accept that there could be disclosure from us, but the problem is how do they deal with the decisions and judgment calls made in the non-respondent banks? And that's not an information asymmetry problem that is fixable on the cases currently put. Then 57, intuition and common sense. We say that the tribunal used a lot of this in the judgment, and it should be recalled that this court said that judges are expected to use their common sense. Making assumptions, for example, in Gutman, that travel card users would be assumed to wish to pay the lowest possible fare. That doesn't require evidence. That's the kind of thing judges are expected to do all the time. And then,
well, there's a big difference, between the revolutionary proposition that judges are expected to use their common sense, as put, in a situation where it's an everyday occurrence. The use of travel card holders, for example, paying the lowest possible fare. But when you start talking about market effect in the FX market and questions of how non-respondent banks might react, I don't think, with all due respect to every judge, that many judges have any sense of that without the assistance of experts. So that there is some, there must be some point at which,
And the expert
as we're
case,
testing, your point is to ask us to say, as a matter of common sense, it must be that the non-respondent banks would have undercut the respondent banks if they had been raising their spreads. That's where I have a problem, because I don't think it's a matter of quotes common sense. That's quite difficult.
and also the expert evidence really for both class representatives was to the contrary effect, wasn't it? That the non-respondent banks would have widened their spreads.
First answer
The
to
case depends on it.
my lord, the first point, to the first point made by my lord Justice Snowden, of course, the tribunal is an expert tribunal, and there's an expert economist on the panel in the tribunal. And here, the expert economist was in the majority. And so, although they're acting in a judicial role, the tribunal does have something extra, which is, and deliberately so, an expert economist, an economist.
Yeah, but an expert economist isn't an expert in the FX market.
No, my lord, but he has the idea, he or she has something additional, which wouldn't ordinarily be available in the court, which is someone who can look at expert evidence, but this expert evidence, and understand it perhaps better than.
But as my lord says, but not an expert in the FX market, whereas there were experts in the FX market whose expert evidence was this is the way in which the market would have reacted.
So my lord,
You didn't call contrary expert evidence. And on the face of it, part of the evidence that the class representatives have, whichever is the right class representative, part of the evidence which they have is their own expert evidence, which is actually about how the market operates. It's not just an economic theory about that. It's actually evidence about, I forget the name of the expert now, but one of them is a gentleman who actually has been an FX trader.
Mr. Knight.
Sorry, Mr. Knight. Is it?
Professor Green, both, yeah.
Yeah.
so just take again in stages.
Yeah.
First of all, the concern that my Lord Justice Snowden raised was that to a judge, in the traditional sense, some of the expert economic evidence may not be immediately obvious, or ordinary judicial common sense may not suffice. The tribunal has something extra. My point is no higher than that. To my Lord the Chancellor's point, there is a distinction to be made between the facts which are summarised in these expert reports and their conclusions, the conclusions that the experts for the PCR has reached. We rely on the facts which the PCR's experts advanced, but we say their conclusions are very, very wrong indeed when we look at the facts which they themselves accept. And we had to put it that high in order to show the case is intrinsically weak, and the tribunal assessing the evidence agreed. And so it's not simply saying, well, we're just to ignore their expert evidence. We positively relied on the facts in it. That's why I took you to so much of it, to show you that even on the facts that they rely on, their conclusions don't hold water. The idea, for example, that non-respondent banks with 25 or 20 or 30% market share could do something, could offer uncompetitive prices in the market, and the biggest player and 70% of the market wouldn't beat them in that situation. That is, we say, something which does not require a contrary expert to dispute. That is obvious.
Did the cat, sorry, I may have missed it, and feel free to tell me I've missed it, obviously. Did the cat say that the evidence about how infection would occur within the institutions by the activities of their rogue traders was unsustainable?
To my recollection,
I don't remember.
I don't remember the tribunal saying that in
Cat
terms.
saying that, for example, the Class A claim that the theory or the evidence as to how a rogue broker would infect other brokers within an institution, within the respondent banks, was unsustainable, obviously nonsense. I don't understand. I can't remember the CAT dealing with that at all, did it?
My lord, neither do I. My juniors will give me a reference if one exists, but in my submission, when the tribunal said that we struggle to see how they can link the infringements in the Commission decision to the idea that all the respondent banks would act this way, they were paraphrasing the point that I put to them, that the Commission decisions find in terms the information was shared within the chat rooms and not shared outside the chat rooms. So we said it was contrary to the Commission decision to find that all of the banks and all the traders were somehow infected by
The
what went on
Commission
in the chat rooms.
Commission didn't say there was no intra-bank, respondent bank infection. That's not the same point. There is, and there is a, as I recall it, there is evidence, pleaded evidence within the wider sense, which said if you have a rogue trader operating on this basis within your institution, it will cause the institution's spreads generally to be higher. Now, what else? Unless the CAT has said for good reason that is nonsense, the CAT has erred, has it not, in deciding that the Class A claim is weak.
So even if the tribunal doesn't specifically address that point, it is included in the conclusions which I took you, in the analysis which I took you to yesterday, because again, we would say it is inherently implausible that a single rogue trader could infect the whole trading desk of his
Inherently
bank.
plausible is code for common sense,
Yes.
Judge. As to which, how can even an economist, mystical economist, which actually, to be fair, I will say, obviously sitting in the CAT, you get an enormous amount of help from the experts either side of you. Don't doubt that for a moment. But they're not experts as to what goes on in an FX dealing room.
So indeed, obviously I accept that they're not experts in FX markets, but the point is that they found, having assessed the evidence, that this was intrinsically implausible. The main point, I think, is that it's one step in a long chain, and the tribunal's concern, as you saw, was that even, and I'm paraphrasing, even if as an answer to this bit of it, they still fail because of the bigger flaws, and I said there were bigger flaws than that one, down the line in the chain of causation leads to market-wide harm. And so even if I'm wrong, and that bit of the case is plausible, it doesn't help them, because that doesn't get them to market-wide harm. So we need to show that non-respondent banks are identifying these losses, isolating them and reacting.
Wouldn't it, and I'll put the point in and I will shut up, I promise you. If the question for the CAT is opt-in or opt-out,
Yes.
and they've chosen opt-in because of a belief that one part of the claim is inherently weak, very weak,
Yes.
but they've failed to spot that that the first part of the case is not as weak because it does have sufficient evidential support, which they didn't deal with. That's an error of law, isn't it?
If that's what's
If.
happened, yes.
Yes.
If that's what's
I
happened.
know you say that isn't what happened, but if that's right, that's an error of law.
If that's what's happened,
That's not just something you leave to the discretion, that's an error of law.
If
It's an
they've-
error of approach.
Failure to address an important question like that would be an error, and it would allow the tribunal to find against me and remit the matter potentially to the tribunal. But my clear submission is that is not what happened, because you can't, because the tribunal understood you couldn't carve out Class A in that way. And that's what when the tribunal said, what about competition in the market? Repeatedly they said it, and that was their way of saying you can't show a separate loss for Class A unless the non-respondent banks are also widening their spreads. That's what I say the tribunal was holding in their analysis, and once that's accepted, then the Class A specific bit is also intrinsically so I've shown you Gutman, and I wanted to just finish on the importance of this certification. So paragraph 60, certification stage. Paragraph 60 talks about practical justiciability, whether the methodology to advance the resolution of issues at trial enable the court to determine the issue. The same language is used by the tribunal. And similarly, at 61, the height of the bar, the methodology needs to show that the matter is going to be workable at trial. And this isn't a toothless exercise. The tribunal has to closely scrutinise the methodology proposed by the representatives. And then this, my lords, just to recall that this is not a normal case. The aggregate damages regime represents a paradigm shift in the dynamics of tortious recovery. The defendant subject to an award is required to disgorge the total loss flowing from its breach. The contrast with pre-existing position, whereby a dominant undertaking exploiting its position through, say, unfair prices, was in practice immunised from the adverse consequences because there was no realistic, I'll come back to this in practicability, because there was no realistic ability or incentive for a small consumer to take it on in litigation. But the introduction of the collective action and aggregation mechanisms reversed the landscape and has in consequence materially heightened litigation risk for undertakings, by which they mean defendants. The CAT therefore plays an important gatekeeper role in certifying claims and will always vigilantly perform that function. It will try and strike a balance between the rights of the class to seek vindication and the rights of defendants not to be subject to a top-down claim unless it is a proper one to proceed. That was what the tribunal is saying again and again in its own words in the judgment.
What the Court of Appeal doesn't say, no criticism, old duck, go on to say is how strikeout is an additional tool in the supervision process, if I can use a very neutral word, because they're focusing on the gatekeeper element of certification step. There is an extra piece, which is strikeout, isn't there, in terms of safeguard points being put. Sorry, I did say I'd shut up, didn't I?
No, my lord, I'm glad you said it because I want to address this also. It is a safeguard. The strikeout right is a further safeguard, but it's a further safeguard, it's an extra safeguard. It's not a substitute for the role that the CAT's given by Parliament under Rule 79.3, which is there in any event where they have to assess whether it's opt-in or opt-out based on whatever they consider, but also strength, if they choose that, and practicability. So in the same bundle of authorities, we look at McLaren. It's the last authority before we go on to practicability. And it is just very briefly on what the tribunal is looking for in analysing methodology.
Which tab's that?
Tab 51, page 1554. Paragraph 46 to 47. 1554. Now, although this is under the heading of case management issues, and McLaren was concerned with supervising methodology after certification, it's useful, again, just to see the echo of the language used in the tribunal. The tribunal's approach, its concerns, were the kinds of concerns that are raised, ought to be raised, and you see that here. In Gutman, a proactive gatekeeper role of the tribunal.
Sorry, Mr. Kennedy, I'm
Paragraph
lost which
46,
paragraph you're in.
I'm sorry, 46 on page 155.
Okay.
And this goes to, I think goes to the point my Lord Justice Snowden put to me about, well, let's just rely on strikeout. Really, isn't that the solution? But what the court says here at the beginning of 46 is that in Gutman, the Court of Appeal endorsed the proactive gatekeeper role of the tribunal. The tribunal can't be passive, it must be proactive in applying Rule 79.3. There are clearly, skipping down 4 lines, there are clearly established strong public interest benefits in the tribunal performing an active elucidatory role, ensuring that large-scale litigation is run efficiently, ensuring defendants aren't confronted with baseless claims, that potentially sprawling cases do not absorb an unfair amount of judicial resource. And the methodology advanced, next paragraph, is an important feature of the process. The level of detail required will always be fact and context sensitive and will turn upon matters such as the availability of evidence, and you have my point about that from the non-respondent banks. But underlying the Microsoft test is the proposition that if a claim is certified, the methodology should be an initial blueprint for the parties and the tribunal the way ahead to trial. And the tribunal in our case was constantly concerned with how the pleadings and evidence and submissions from the applicants were showing a way ahead to trial, and the tribunal found that they did not. So we put these fifth volume of authority away, and my final point on this is about our respondents' notice. We have, after the judgment in Meta, we applied to amend our respondents' notice. Before I take you to that, just to explain why we did it, I would submit, regardless of what the tribunal said in the Meta and Gormson case, it was clear that in their judgment they were concerned not just with dry pleading points, but with the methodology generally, in the sense that I've been showing you in Gutman and McLaren, how this thing can go to trial. Then we saw the judgment in Meta recently, and I'll just take you to that briefly, just to show you what the President said there. It's in the 6th volume of authorities.
Yep.
Tab 50. Sorry, 5th. Sorry, I'm wrong. Sorry, 6th, yeah, 6th volume, tab 63, 6.3.
Yep.
Judgment of the tribunal, the President again, that it's February 2023. And if you skip ahead, please, to page 2041. In that judgment, there were several concerns raised about the lack of a methodology on the part of the applicant. And on page 2041, if you go to footnote 38, having described, actually, if you go above, you see the paragraph that's in play. It's the paragraph at the top of the page 2041 from however. However, it's entirely right and proper the tribunal be satisfied that the PCR knows how it is proposed to make the claim good, that what directions the tribunal will or in due course have to make to ensure an effective trial. And then down to footnote 38, the President says, or the tribunal says, O'Higgins, our case itself, is a case in point. There the tribunal, whilst understanding the theoretical basis for the claim, had no sense of how that claim would make good at trial. The outcome was not to strike it out, but to refuse to certify on the basis sought by the two proposed class representatives. And although the respondents' objections were never framed in this way, this was very much a case where the process, that's the Microsoft methodology test, was not satisfied. So when we got that judgment, we applied to amend our respondents' notice for the avoidance of doubt to say that the tribunal's concern was about methodology in a process sense. And that was another reason to uphold the judgment. So I have a formal application which the tribunal will consider in due course to amend our respondents' notice. I'm not going to take you to it, it's one sentence. It's in view of the time, I'll just give you a reference. First court of law. It's in tabs 13A and 13B to adopt, to formally make the point that I've been putting to you in submissions. Yeah. So, because, and just to explain why, because when the tribunal said it can't effectively manage the cases to trial, it means lack of methodology. And when it says it can't work out how the applicants can make good their case even with disclosure and evidence in the future, again, that's a methodology concern. So I'll move on then, if I may, to practicability. And I'll take the point of law first. This is the second Evans ground and the first O'Higgins ground. The error of law is said to be that in refusing to certify, the error is that the tribunal should have certified opt-out as a matter of law when it accepted that the application would not proceed as opt-in. And our submission is that opt-out is not an entitlement of last resort. Opt-out collective proceedings exist to ensure access to justice. access to justice means an absence of any practical obstacle to bringing the claim. And I mean practical obstacle in the wide sense used in the Merrick's judgment and in Paturel. And here, the tribunal found, as a matter of fact, there was no practical obstacle of any type. Having considered extensive evidence and documentation, the tribunal found any unwillingness on the part of potential class members to opt in was likely to be for other reasons, not linked to any access to justice concern. And the appellant's short point is, and they were very frank about this, that if opt-in is not going to happen for whatever reason, it cannot be practicable. But my submission is that does not follow automatically. The tribunal does need to ask why, not whether, potential class members are unlikely to opt in. And that's because if the reasons for not opting in are the types of concerns raised in Merrick's and Paturel, that does point towards certifying as opt-out. If the claim values are too small, if the class members are unsophisticated, hard to inform, hard to identify, if the opting in is not worthwhile, comparing likely cost or hassle to recovery. But if none of these obstacles arise, if the reasons for not opting in have nothing to do with obstacles like that, that does not suggest that opt-out is the answer, still less that it's required as a matter of law. And that's why we say practicability is such an important factor in the assessment. And the tribunal assessed whether obstacles like those existed and found that they did not. And in all of the discussions between your lordships and my own friends on this issue at the beginning of the appeal, when the specifics of practicability came up, the obstacles that were raised were these kinds of practicability obstacles, because that is the vice that the Act seeks to address. So my lord, the Chancellor suggested that class members may not even know they're in the claim. Well, the tribunal addressed that. It found that the class members were generally sophisticated and could work it out. Mr. O'Higgins' own evidence, his first statement said that class members could be identified easily, and I'll come back to that. My Lord Justice Green asked how the tribunal could have found there was a core group that could easily opt in. Well, the tribunal found that because 680 class members have a claim worth £2 billion between them. And thousands of class members have claims worth, in theory, hundreds of thousands of pounds. And that was well worth doing on a cost-benefit analysis and would be more than enough, we said, to ensure funding, because the funders are concerned with the value, not the numbers of class members. So if you're looking at funding, 90% of the claim value would be in play. And as regards the fear of retribution, the tribunal examined that also on the evidence and found that it was not made out. And I'll come back to that too. And Ms. Wakefield said, my friend Ms. Wakefield said, it was flatly contrary to the whole regime to rely on the fact that class members do not want to join in. That fact is always irrelevant, she said. But we say no, in this case, it's highly relevant because their reasons had nothing to do with the obstacles which the opt-out regime was designed to overcome. And it's absolutely clear from the pre-legislative materials that the regime was designed to ensure access to justice for consumers and
Only
SMEs.
access.
Sorry?
Only access.
Effective access, practical access.
But nothing else,
meaningful
no other
access.
statutory purpose or object behind the regime?
By far and away.
Including the creation of ex-ante deterrents and incentives.
That cannot, first of all, that was not the primary objective. It wasn't the main objective of the regime at all. It's been
Well,
mentioned
you
in
say
the case.
that, I mean, it's what Merrick's described as one of the important objectives. I mean, one's got to be a bit careful about the Bayes report. I mean, it was 3 years before the Act. It was a fairly thin consultation. You haven't taken us to, but you've taken us to the Civil Justice Council. I mean, there's only a certain amount one can deduce from that as a guide to interpretation. But we've got the Supreme Court now to guide us as to what the objectives are. And I entirely accept that access to justice is one thing, no doubt about that, and plainly applies more cogently in a case such as Le Peterel than here. But
what about the fact that if on the evidence, having applied a sceptical and searching eye to it, the cat comes to the conclusion that opt-in is a killer, what about then public interest incentives? Deterrent.
So again, in our submission, let's posit a situation where the tribunal finds as it did, there was absolutely no access to justice reason for certifying opt-out, none at all. But there was a potential side benefit of deterrence. That would give deterrence a role and prominence which is completely inconsistent with the purpose behind the statutory scheme. That would be the tail wagging the dog, not least because deterrence is primarily applied by reference to the regulatory penalties that are imposed and were imposed on these banks. But that point about the fact that banks are already penalised under a different regime is not my main point. My main point is it would be extraordinary if this case were to be certified in circumstances where there was no access to justice issue at all. And if these are good claims, because this is part of the tribunal's reasoning, if these are good claims, there are hundreds of potential claimants with claims worth billions of pounds between them who can easily bring them, and deterrence will be served that way. But the tribunal did note that...
What about all the rest, the smaller claimants?
So
And there's a large number of claimants, some are big, some are medium-sized, some are fairly small.
yeah, I'll come back to those. I'll come back to my lord, don't worry, I'll come back to it. But my basic point is, in terms of what this regime is designed to do, to ignore access to justice completely is to ignore the very foundation stone of the whole regime. And that's what Merrick's and this court is concerned with all of the cases we were looking at. So to say, even if there's no access to justice problem at all, if a group of massive banks with claims worth billions of pounds can't be bothered to opt in for whatever reason, but there's no access to justice issue, and there's a finding they wouldn't opt in, you are obliged as a matter of law to order opt-out for them. That would be an extraordinary result in view of the purpose underlying the regime, as this court held. And that, I suppose, is the last point I make before I get into the detail on practicability. If this case, and at the very least the major part in terms of value of this case, if that isn't opt-in, it's hard to imagine any case that would be opt-in. The regime was not designed for these kinds of class members. So I'll move on then to the detail of practicability. And this is the fourth Evans ground and the second O'Higgins ground. And I'll start with the legal test, and I'll go back, if I may, to Le Pacturel, which has been put to me many, many times. And Le Pacturel is, as we know, in the fourth volume of authorities, tab 44. And its page starts, ask you to go please to 1231. 1231. On the left-hand side, I'm going to use it's paragraph 26 at C. Referring to Merrick's, recalling the statutory purpose was one of providing effective access to justice for claimants, for whom the pursuit of individual claims would be impracticable or disproportionate. The majority then observed also that the anti-competitive conduct would not be effectively restrained if wrongdoers could not be brought to book by mass consumer claims. So there is that reference to bringing wrongdoers to book, but they would not otherwise be brought to book because consumers would have an access to justice problem. The link to mass consumer claims is part of that analysis. Because it went on to say the proposition that the evident purpose of the scheme was to facilitate, not to impede, the vindication of those rights that would otherwise, I paraphrase, be impeded. And then down to 28 and 29, middle of 28, the system was designed to facilitate access to legal redress for those who lack awareness, capability, or resolve required to take the positive step of opting in to legal proceedings. Pulling the threads together, the principal objective of the collective action regime is to facilitate access to justice for those, in particular consumers, who would not otherwise be able to access legal redress. And then move on to 66, because this is about convertibility. And my lawyers put this to one of our friends at the beginning of the appeal, paragraph 66. Whether in reality you can find class members who would opt in, whether they would in fact convert into opting in class members. And let's begin at the top of page 1244. Subsequently, 3 lines down, the Supreme Court has made clear that convertibility is an issue of substantial importance. Merrick said the key purpose was to give consumers claiming modest sums a mechanism whereby they could vindicate their claims in circumstances whereby absent that mechanism, the claim would not be brought. The same logic applies to convertibility. And the opt-out, opt-in decision. Be little point in the tribunal certifying a claim on the basis it facilitated a large-scale consumer claim, which otherwise would not occur, but then ordering it to be opt-in with the consequence that few took up the option the claim withered away to nothing. Now that's relied on, but entirely out of context, because the lack of convertibility in this sense here arises from the same practical concerns, that the claim values are too small, that the consumers wouldn't actually opt in. So you still need to ask, this does not take away the need to ask why would class members not opt in. Even when you look at convertibility, you have to ask why. If you move on please to page 1245C. 1245, this is C on the left. We're now in the tribunal's judgment, which is upheld. You know, why will they not opt in? And indented paragraph 112, and this is the point again put to me, that there's a real difference between the option of joining a legal action at the outset and claiming damages entitlement later on, once the case has been won. But why is that? It says especially, but one can see in this case, in the Le Paturel case, with the demographic of at least most of the potential claimants here, there may well be a reluctance to sign up. Again, it's asking why, on the facts of the case, would that make a difference? Because with this demographic, there may well be a reluctance to sign up to a legal action where the risks and complexities will have to be explained to them, ordinary consumers. And that scenario differs from that in which they're simply asked to collect a defined amount at the end. Again, that's completely sensible when one looks at consumers. And as canvassed with the Chancellor during the hearing, that's the point I think my Lord Chancellor raised, the distribution of damages could be achieved without even getting any active participation from them. They could simply be credited with a relevant amount. That consideration about the difference between opting in and claiming damages later on is far less material when one looks at the class composition that I'll take you to. And moving on then to the bottom of 1245 is a reference to the Supreme Court in Lloyd. And again, this point was put to me, or put to my learned friends. Paragraph 71. Again, what are the kind of practical obstacles that point towards opt-out? For an opt-in regime, a claimant has to take active steps. There's an administrative cost over the page, as the solicitor conducting the litigation has to obtain information to determine whether they're eligible to be added. There needs to be advice. You have to enter a retainer. For claims which individually are only worth a few £100s, this process is not economic, as the initial costs alone may exceed the potential value of the claim. We are a million miles from that in this case. And that's not just a point of fact, that goes to the very purpose of the opt-out collective proceeding. And then going down, please, to staying in that same page, 1246, paragraph 27. What are the explanations for low participation rates in opt-in regimes, lack of awareness of an opportunity, the natural human tendency to do nothing when faced with a choice which requires positive action, where there's no immediate benefit to be gained, and the consequences are uncertain and not easy to understand. And the tribunal found, as a matter of fact, that the class members in this case were sophisticated generally and well able to understand what was in their interests. And the lack of understanding and difficulty and hesitancy is referred to later in that page on the part of consumers. Over the page, 1247, paragraph 74, look at the factors in the Le Paturel the ability of a claimant to convert identifiable contacts into litigants is an important factor. It's not just about identifiability and contactability. The tribunal, court said, properly looked at relevant factors: size of the class, the scale of the award, the impact of these on funding as important considerations. These might be sufficient in themselves to justify opt-out, but the CAT also considered more subjective characteristics: the age profile, social class, and technical ability. Now, these will not be the same factors in every case, but they all go to the practical obstacles to opting in. And 1250 A to C, it's at the very top of the page. It's a highly fact and context sensitive issue, practicability. The tribunal has to use its expert judgment to envisage how the costs and benefits of litigation will play out. And the view the tribunal takes will be a conclusion reached by an expert body with a growing depth of experience in the conduct of collective proceedings. And practicability includes being doable, but also goes further. It requires the court to ask not just doable, but is it reasonable, proportionate, expedient, sensible, cost-effective, efficient, and so forth. And my short point is that it's not reasonable, and the tribunal agreed, proportionate, sensible, or efficient to force large, sophisticated class members like banks and hedge funds with £1 million claims to put them into an opt-out collective proceeding when they are well able to access justice themselves, or where they have in some cases positively declined to join for reasons that have nothing to do with practical obstacles. I would go on then, if I may, to the, and I'm conscious of the time, I've now hit my hour, and I'm just over my halfway point, just to apologise and to draw that to your attention. But I'm now going to the class composition. The vast majority of the class members are very well resourced, and by sophisticated, the tribunal didn't mean expert in FX trading. The question is, are they, do they have the capability and resolve to be able to opt in if that's in their economic interests? And for that we get Ramirez 1, the first Ramirez report, key documents, volume 1, tab 11, page 567. Paragraph 57. And the class members are divided, as you know, between financial institutions and non-financial customers. Paragraph 58 on page 567. Paragraph 58 on page 567. Who are the financial institutions? The italicized sentence says smaller banks, investment banks, securities houses, mutual funds, pension funds, hedge funds, currency funds, building societies, leasing companies, insurance companies, financial subsidiaries of corporate firms, and central banks. And paragraph 61, Professor Ramirez looked at the non-financial, non-financial customers, and who are they? They're the ones dealing with FX dealers, and they're largely importers and exporters of goods into the UK that require foreign exchange in their regular course of business. Top of paragraph 61, on page 569. And then 63, he notes that he has excluded high net worth individuals who may transact directly with FX dealers through, say, family offices. And we go down to 66, please, now on page 571. Page 571, he's excluded micro and small-sized enterprises. So again, we're moving further and further away from consumers and SMEs. Then at 69, this paragraph, which was relied on heavily by my learned friends. Now in 69, I think it's Mr. Ramirez, I think I've given the chair maybe incorrectly, but Mr. Ramirez at 69, 4 lines down, says he's not included certain types of persons who may have traded FX, including small or micro enterprises and individuals, he says including the populations of these customers in his preliminary calculations would include numerous individuals, or may include numerous individuals who are unlikely to have traded FX. If he'd included small enterprises with, say, 10 employees, the estimated class size would increase to over 100,000. He says that would require a degree of speculation. He thinks that those limitations will be rectified following disclosure. So his estimates for certification are a reasonably broad overview. And he says conservative because he's cut out the really tiny individuals. But this was the long tail, and the tribunal said in its judgment that it was not going to allow this reservation of rights to alter its ultimate conclusion on certification. And in my submission, the tribunal was entitled to do so. It was entitled to rely, for the purpose of certification, on the class offered to it by Mr. Ramirez for the purpose of certification. And the next report of Mr. Ramirez shows the class members in more detail and their claim values. Second Ramirez is in the second key documents bundle behind tab 38. Page 2621, please. Tab 38, 2621. We have a table that tells you the financial class members by firm size. And what's interesting about this is that some of these very wealthy financial institutions have often fairly low headcount. They would be SMEs on the basis of headcount alone. You see that on the number of employees on the far left-hand column. The point is made that a large percentage of class members have, even though the financial institutions have small headcounts. But we said to the tribunal in our pleading that the BT, for example, the BT pension fund has a small headcount. It was before the tribunal that it had 173 employees, but it had assets in 2019 of £58 billion. So going on headcount alone for the financial class members is potentially misleading. The same could be said for hedge funds. And for the non-financial business entities, we see at 19, near the bottom, about 76% are medium-sized and about 24% or 23% are large enterprises. These are the ones, importers, exporters, using FX deals. And now we go to the claim values, and I do rely heavily on this when you ask about, when one asks about practicability. Go please to page 2628 and table 4. The first point to make here is about the share of the value, the total value of the claim. Because the financial institutions make up 90% of the value of the claim. So if the financial institutions have no practical obstacle to opting in, if they were to opt in, that would give you 90% of the VOC. And a lot is said about the non-financial customers. I'm not denying that the rights of individuals to redress is important, but if the concern is about having volume in the claim, attracting funders and getting momentum, the big institutions will give you 90% of the VOC. And then please go to 2630, where we see the non-financial class members. Now these make up 9.6% of the VOC, and...
Can I just ask you a question? Let's assume you're right. So you've got a small number, relatively small number, who account for a very high percentage of the total aggregate damages. And you've got a large number of smaller individuals, SMEs and so on, who account for 10%. Could the CAT make an opt-out CPO for the 90% who equal the 10% of the claim?
Yes.
And if so, what would you do with the rest? Why wouldn't you just tag them on? What would be the case management reason for severing them off, just because in theory they could, but you've concluded they wouldn't?
It goes to the first point that I made on this issue, which is access to justice. The case management concern arises separately. One asks, first of all, what does access to justice require? it was an option for the tribunal, and it would be an option before them if you find against me and remit, to, and I'm not saying it's an option that we would support, we would oppose it because of the strength issue, but in terms of practicability, the tribunal could say that we will certify opt-out for the very smallest, the very numerous class members with the very small claims. Well, they're not very small claims, but relative to the massive claims, they're smaller. And not certify for the large, for the banks, hedge funds and so forth, on the basis that they have no access to justice issue at all. And case management doesn't arise. Case management arises if they have claims which need to be vindicated for and are not being vindicated for access to justice reasons. If the hedge funds and commercial banks wish to sue for their £2 or £3 million, which is the claim value that the PCI say, they can do so, and that would be case managed alongside the opt-out class action, as indeed the tribunal currently case manages in the interchange cases, potentially if they're certified, the class actions along, and in fact in ro-ro shipping, there are certified class actions and individual proceedings brought by the large car companies. So they are being case managed in parallel.
Can you link an opt-out and an opt-in and make two orders? So the 90% of smaller claimants get an opt-out, the 10% get an opt-in. You run them both together. I mean, it may have an effect on funding, but it may have an effect on disclosure. Could you do that?
Yes.
I mean, what would be the benefit in terms of case management? I suppose you may get disclosure from the named opt-in defendants. But I mean, in logic, they may just hang back, serve their claim, ask for a stay, wait and see what happens, and then either sue or settle. What's the point?
There are two separate issues. One is the access to justice point, which I
understand that. Got that.
the second point is, could it be done? If the tribunal wanted to certify opt-in for the very large hedge funds and banks, they could do so. It is possible to do both necessarily in the scheme, because as the court knows, for non-UK domiciled class members, the Act tells us it can only be opt-in. So, and so there will necessarily be, if opt-out is certified, an opt-in bit where the foreign class members can.
We may have to grapple with that, but assuming that you could do it, I'm just asking what would be the point from the CAT? I mean, apart from you made the point about access to justice, that they could but they haven't.
Well, because
I see that, but what would be the point?
The point would be that the concern to ensure that everyone's in the tent and they could all be case managed together couldn't possibly override the fundamental purpose of the collective proceeding regime and the risk of oppression and so forth that I took you to. The consideration that my Lord raises, which is, well, wouldn't it be great to have everyone in and case management together, that doesn't come close to overriding the bigger problem, which is you can't just certify people for case management purposes. There has to be a reason, there has to be an access to justice problem that prompts an opt-out class action. And if there's no access to justice problem, it's not appropriate to say, well, it'd be great to have all the banks and hedge funds in this opt-out class and run the thing together.
You've got your access to justice point for your 90% of smaller operators.
Yes.
And what about the ex-ante incentives for the other 10% to combine the purposes?
The ex-ante incentive for them is that they have a claim worth £3 or £2 million, and they are massive, rich institutions with in-house legal teams and lawyers. And if they're well placed to make their own minds up and join in. And for example, in ro-ro shipping, in that case, a car company has brought a claim against cartelists, self-funded of its own volition. It's a big company, it can do that. At the same time, there is a class action brought by consumers who feel that the cartel caused them loss. And they're being case managed effectively together by the tribunal.
How small do you
And disclosure will be shared between them.
How small do you need to be to benefit from collective proceedings? Where do you draw the line?
So in my primary submission is that the regime is designed for consumers and SMEs, and that should guide the tribunal.
So define for me, where's your line?
I'm afraid it's not appropriate for us to even suggest that kind of line now, because it's complex assessment which the tribunal is best placed to undertake. All I can say is that what's clear is that the 680 class members who have a 2 billion claim between them, who have claims on average between £2 and £3 million, they should not be in an opt-out action. At the very least, the line can be drawn there. Or, at the other extreme, you
Well,
could...
I'm just struggling at the moment to understand this. I mean, this whole thing is under the heading of sort of practicability, I think. Where's the line? How big, how small do you need to be to benefit, and how big do you need to be not to benefit from collective proceedings? I mean, the problem here is that I just wonder about the practicability of your approach, which seems to require a line to be drawn somewhere. Everybody can say, well, okay, I'm trying to, I don't know, Shell is probably big enough to look after itself if it wants to, but somebody who is a sole trader but who happened to have a fund of euros and needed to have them converted to sterling is small enough to justify being part of collective proceedings. Where do you draw the line? How do you formulate it?
And a related point surely is that if in this example you've certified opt-out for some people, unless you've actually defined in very, very careful and full terms what the criteria are that you need to satisfy to be in the opt-out section, how people who hear about it, because they're going to be notified, what do they do if how do they know whether they're going to be in the opt-out group or they need to opt in for themselves? I mean, they're not, on this hypothesis, they're all in the UK, so obviously if they were abroad they'd know if they want to participate they're going to have to opt in, but I just think this is I mean, in a sense you've walked into a bear trap about practicability.
My lord, may I climb...
It says, doesn't it? Practicable, you have having regard to all the circumstances.
Indeed. All the circumstances relating to
You
practicability.
might say that if what you're postulating is an example of a bifurcation, some opt out, some opt in, you've still got to look at the issue of the practicability of opt-in proceedings in those circumstances, because they're part of them circumstances.
Absolutely, my lord, yes.
And it might be said, picking up my Lord Justice Green's point, that if what you've got is an opt-out regime for a whole group of people, what is actually practicable is that everybody is in the opt-out regime rather than having a bifurcation.
Merrick's does say judicial efficiency is the third of the statutory objectives behind the collective regime. It was Merrick's, wasn't it?
Yeah.
So let me take again those in stages, because if I were climb out of the bear trap that I made.
No.
The first point is, where does one draw the line? How does one draw the line? And the guiding principle in drawing the line is access to justice. So when one asks, among this vast class, where does one draw the line? One has to ask, for whom is there an access to justice problem? For whom can it be said that the value of their claims is so low, they may be misinformed, they may struggle with the underlying principles. For those people, access to justice may be a problem. Again, this is all on the basis that I deny everything and strength means it shouldn't go ahead. But assuming that against me, that is how one draws the line. And so one asks, by reference to this evidence, who are the people who are struggling? If Mr. Ramirez had put forward that extra class that he reserved rights in respect of, and there was evidence about those people really would struggle. They're not sophisticated, even though they deal with FX dealers in a commercial market. But put that to one side. If one could identify access to justice problems for a class, even at a high level, not in detail, that would be a proper basis for drawing the line.
Satellite litigation. Who's in and who's out?
This is a case where they're seeking 3.2 billion
In aggregate.
dollars. In aggregate.
So the opt-ins have got to be individual claimants,
Yes.
claiming 2 or 3 million max.
The concern is satellite litigation. A bit of satellite litigation is a small price to pay to avoid serious injustice and a car crash in the tribunal when the thing has to be tried. But injustice is the primary concern. But back to the points that I'm addressing. The first is that's how one draws the line. And that allows you to exclude from the class very quickly the 680 with their £2 and £3 million claims. And that links very closely to the point put to me by my Lord the Chancellor. He said, how will people know? I mean, realistically, if you're drawing a line and a line is drawn, how will class members know if they're below or above the line? It could be very difficult. We say not so, because in this scenario, the people who are misinformed or small or weak, however implausible that is, they will be in the opt-out class. The people who will be excluded, by definition, are the ones for whom the tribunal has found that there's no access to justice issue. May I just, because otherwise I'll lose my train of thought. They're the ones who, I'm sorry, I genuinely will forget what I'm saying.
Let me just write something down because I'm going to lose mine otherwise.
But that means that the people who will be excluded from this class will be the very ones who are very well placed to know if they're in the class or not. Hedge funds, commercial banks, pension funds, building societies. They will have lawyers who can work it out for themselves as the tribunal found. So for them, there is no practicability issue. And now just quickly look at these notes that I've been handed. See, that's right then.
It probably says call for a break.
And it probably is time for.
How close are you to finishing?
I could finish very quickly if I was simply going through my points. I'd be finished in 20 minutes.
Okay, we'll take a break now then. 5 minutes.
Does Snowden want to ask me his question before
I've
he
written it
goes?
down, but
It'll
the lure of you finishing in 20 minutes is tantalising.
Could I have the question before you rise, just so I have a little bit of time to think about the answer?
You said that you would, one amongst the factors you'd use to define your class is the claim value. How do you apply that at the start of the proceedings? How do people know what their claim value is? How do you determine that as a factor in deciding whether you're in the opt-out group or you're required to opt in?
I'm glad I asked for that question.
Right, you've got 5 minutes to think of the answers.
All right.
Thanks very much.
worth.
I will mention. Sorry about the time.
No,
only
it's
had-
fine.
I only
We love having work on fine.
I only had 10 pages. I literally 10 pages of notes. All I had. You know, I make a point of pride to finish on time.
Oh, yes.
I think you were missing that.
Yes.
Some people keep looking to 3.
But I've got all of my points from yesterday that is affecting stuff. So I'm addressing practicability.
Yeah, I thought that was going to be.
All of it. Oh,
And then I
okay.
was going to do strength.
Okay. No, I thought I was picking up like Merrick's Lloyd and Google, like I said to you.
Oh, okay.
Yeah.
Okay, so not,
Yeah.
not really strength.
Not massively. So just one point on traders are, and then one point on data to answer the point he made about my data yesterday. But otherwise, sorry. Okay. Yeah. Reply in 3 stages.
Yeah.
Never. Well, see, I don't know if I'll be saying that much, really, because a lot of the ASR stuff you're doing. You see what you think? Okay.
Take it in.
Sure.
Is that okay?
Yeah, that's fine.
It's just that otherwise I don't know.
Yeah, we'll probably reduce the risk of duplication.
All right.
So, my lords, to my lord Mr. Snowden's question, how are we supposed to identify these claimants? How can claim values, class members, how can claim values be of assistance?
I was discussing claim values in the sense of whether the opting in option was worthwhile. I didn't mean to suggest that it would be the basis for identifying the class members. If I said that, I was wrong. The way in which class members would be identifiable by the tribunal and by themselves would be by reference to either the well-recognised formula for SMEs, which is a term of art, it's defined, but that would go alongside turnover, my lord, because
Not profit, not.
if one is looking for a rough and ready guide, something that's easy to...
That's the problem. I'm fascinated to think that SME is a defined term somewhere with sufficient precision to enable somebody to figure out whether they're in or out.
It is a defined term, but the best guide, one is looking for a rough and ready guide which can be used...
I'm fascinated for another entirely sort of outside the competition field, but where is it defined?
Where is it defined?
There are different, well, I'll be given a reference at some point in the proceedings below, but I think what we discovered was there were different definitions for SMEs in different legislative regimes.
Well, that's why.
Yeah.
So you may have to choose one.
Somewhere that's mentioned, whether it's in the judgment or somewhere else.
But
Okay,
even
give me
if-
the reference.
even if I'm wrong about that,
So you'd
it's
say
fine.
nothing to do with claims, it's a question of how big you are by reference to some financial metric,
Yes.
such as turnover,
And it would be,
as defined in your last accounts.
yes, because remember, these are not consumers, these are not small or micro businesses. These are businesses which one would expect to have some form of accounts in which their turnover or some other financial metric could be recorded and would be accessible.
Sole trader.
But sole trader dealing with an FX dealer, these are excluded, unless they're sophisticated sole traders. They are excluded. I mean, to be a sole trader, it's possible, a high net worth individual, a retired hedge fund partner who has set himself up as a sole trader and trades with FX dealers, a very successful barrister, and then we have somebody in the room who trades directly with the FX dealers in the customer facing segment. But if someone
I'm not going to say who's blushing.
Exactly. If someone's doing that, in my submission, they're well able to check their tax return and see their very considerable earnings and decide for themselves if they fall on the right side of the line. And it would be a rough and ready metric. I'm not suggesting that precision is the goal, but it could be done. And in fact, since you're all in Ramirez 2, that's how he, in part, how he approaches the classes himself. If you go to, this is in Ramirez 2, key documents bundle, tab 38. Behind tab 38, page 2695. 2695. And this is the average claim values for financial class members. We're looking only at the financial class here. Page 2695. And I draw it to your attention for, I suppose, three purposes. First, he has examined the annual turnover for the class and the financial class members. So the PCRs themselves have sought to, by reference to publicly available data, work out class member numbers by annual turnover. So it is possible that they themselves apply their minds to the annual turnover of class members. And since we're on this page, you'll see where I'm getting the 680. If you go to the bottom right-hand corner of the table, you see that the average claim per class member, 2.2 million, 3.4 million. And that's for 338 class members and 342 class members. The other 680 with the approximately 2 billion claim between them, the average claim value is between 2 and 3.4 million pounds. And in relation to those types of class members for whom it said the opt-out regime is appropriate, when I say they are well able to look after themselves, I say that by reference not only to, that really is something we would say is obvious, but also what's happened in reality. Because you see, my lords, in the papers, a reference to the Allianz case, which is now settled. But the Allianz case was a case where hundreds of entities, large financial entities, sued the same defendants, my client included, in the High Court for damages arising out of these same cartel decisions. But they brought a follow-on action and a standalone action. They recognised, I think, that they needed much more in order to land their damages case. It was not the same as this claim. And they did it. They did it with their own solicitors and their own barristers, as any commercial claim is brought, and it was worth a significant amount of money according to them. It's since settled, but it demonstrated in the most obvious, concrete way how class members of this size can look after their own
Just out of interest, would you draw the line anywhere on that table, and if so, where?
I'm not drawing any lines, my lord, in any way that could be held against us. I only repeat the point I made earlier, which is that on any view, we would say all these financial
If
class
you look at the
members.
bottom right-hand corner, well, I sort of get why you might do that. But where else on that table could or should the line be drawn? Or indeed, are you saying that all these people fall outside the scope of the collective remedy, collective proceedings regime, just because they're big financial institutions?
That is what I say. I must say it.
So, so why are we looking at the table? I mean, you just say none of these people are intended to be benefited by the collective proceeding regime that Parliament has enacted, full stop, end of story, that's an end of it, isn't it?
But because I had to make good, I've been banding around figures and I haven't shown you the source of my submission. So I wanted to show you where it was coming from.
Yeah, so I was just
But
saying,
also-
so where is the line?
On this table, I said at the most extreme line is the one which is for these £2 billion, 680. But in my submission, this table really, none of these people could be an opt-out because their average claim values, you see what they are, and these are sophisticated financial class members. There's nothing to suggest that the opt-out regime was designed for them.
Who's going to take on a claim for £220,644, even if you're quite a big organisation?
Because more to the point,
Wouldn't cover the interlocutory costs?
those people with a turnover of up to 500, up to £500,000 are 15,684 class members with an average claim of £15,000.
And that goes,
That's exactly the sort of group for whom there's no incentive to opt in to proceedings, or very little incentive. It's a
but you've got, my lord,
you tend to write it off.
that goes right back to the problem identified. Why is there no incentive? There's no access to justice problem for them. And remember, in opt-in
No, I understand that point, but
proceedings,
if you were going to have your, if you were going to draw your line, I mean, it seems to me you would put those people into the opt-out class. Anyway, there we
again-
are. We've debated this enough, I think.
if you're against me on the basic principle, which is unless it's an access to justice problem, you shouldn't be ordering opt-out, then I'm wasting your time. But access to justice is the key here, and even if they have a claim for £15,000, if they're sophisticated entities, as the tribunal found they are, and remember, my lord, opt-in is easier than simply launching your own case in the High Court. An opt-in means there's a single from the solicitors, there's a single team. It's much easier. There's very little to do, and the costs are minimal. A prudent company with a large turnover may well say, well, actually, we will sue for £15,000. But if they choose not to, because they can't be bothered, that's not an access to justice problem. That's a very different consideration. And the opt-out regime was not designed to vindicate the rights in those circumstances. And that's the key point of principle that I'm pushing to you.
This part of your case really depends on your access to justice point.
Yes.
And if there are other considerations which go to the issue of practicability, then I think you'd accept that the conclusion that this claim wasn't going to go ahead if other considerations are permissible. I wouldn't. This can hardly be described as practicable.
Other considerations are permissible, but if there's no access to justice problem at all, then I would say that the tribunal was well within its rights, well within its discretion to say where there's no access to justice issue at all. The fact that there may be some separate interest in deterring banks, that doesn't possibly override all the other considerations which point in favour of opt-in. It's a factorial assessment. There wasn't a black-line distinction that was drawn. And if there's no access to this problem at all, then it would be very odd in my submission to set this aside. they were entitled in those circumstances, since the whole regime is founded on the need to surmount practical obstacles to justice, and not to force banks and hedge funds into an opt-out proceeding. But even if I'm sorry, the reference for the definition, my lords, if you're interested, for small and medium enterprises, I'm told, is in sections 382 and 465 of the Companies Act 2006. There is at least a definition in those sections of the Companies Act. But we've been focusing on the very largest class members, for whom I say there is no question that opt-out should be ordered. But I stand by the point that we make in our submissions that even for the smaller claim values, for non-financial class members, we're still dealing with sophisticated entities. There's none of the considerations that you saw in Paturel or Merrick's apply to them either. And the claim values, even £3,500, are far above the low value claims that we saw in Merrick's and Gibson and so forth. If they want to apply as people do in group litigation orders all the time, and they can do so. The Dieselgate, this is raised below the Dieselgate group litigation order. Tens of thousands of individuals opted in for claims of about that amount, £2,000 to £3,000. I think there were 90,000 class members in that claim ultimately, and that was also funded, I think, by, in fact, Therium's evidence before you, Mr. Purcell's evidence, is that Therium funded that group litigation action, which was an opt-in, necessarily an opt-in action for tens of thousands of consumers. I'll give you the reference. Mr. Purcell's evidence, when I get to it, I'm going to just give you the reference. I won't take you to his statement. So, moving on then to the judgment, because criticisms were made how the tribunal approached this question of practicability. We go through to paragraph, so to page 293. 293. Uh, 293 and paragraph 121. The criticism here was made that the tribunal analysed practicability from the perspective of class members, or notional class members, and excluded the perspective of the PCR. But the approach they took was correct. The question is access to justice for class members, so it's their perspective that's material, primarily. And they deal with this at paragraph 1221 and 1222. You've seen these, so I won't read them out to you again. Then 1223, they're not saying that opt-out proceedings should be refused because there's no buy-in. That would be to render opt-out nugatory. We do have to ask why putative class members aren't coming forward when they are being sought out by Mr. Mason and others. There has to be consideration of the practical bars to opting in, lack of knowledge of the infringements, ignorance of the action, cost of participation, and so forth. These were the factors which the tribunal took into account. And they were told you've got to look at it from the applicant's perspective. But they are concerned about that. And they go on to say that they look at it from the perspective of class members, but they will consider in that respect all the evidence before them. If you go over the page to page 295, in paragraph 1225, Roman 2, they say the tribunal is obliged to consider from the totality of the evidence before it, however produced, whether opt-in proceedings are practicable from the standpoint of the putative class member. And then Roman 3, in resolving this, they will obviously have regards to all the material, including the evidence of the applicant. So they were accepting that they'd have to consider the evidence of the applicant, which referred to funding and so forth, in considering practicability from the standpoint of the class member. All of this is material in deciding what's in the class member's best interests. And at 4.3, now we're going on please to page 434, coming to the conclusions. 434.
29552, do you say they're right to sort of postulate the hypothetical class member on the Clapham Omnibus?
Yes, because if they're asking,
How do you do that? I mean, this is a test which is, I'm not talking just about competition law now, but this is a test which has proved dreadfully difficult in all manner of areas, but particularly, for example, company law, where you have to try and postulate the hypothetical member of a shareholding class, where the class is not homogeneous, you know, where you've got big shareholders, little shareholders, people who have certain interests, other interests. I mean, the class here is not homogeneous. How do you help? In fact, I think I said in a different context, in a European insolvency context recently, that actually it's just not helpful to try and postulate this hypothetical member, because, you know, what are you looking for? An average member? How do you pick this person?
so the tribunal did not fall into the trap of saying we will have one average member which will represent the whole class. The tribunal recognised the problem with averages, that the danger in averaging everything out later in its judgment. When the tribunal speaks of a reasonable class member, all it's saying is we're looking at the class members as presented to us and asking what's reasonable. Looking at them without knowing who they are. Obviously, in a certification case, you generally won't have evidence from class members themselves. So in asking what's in their best interests when they are not before you, the tribunal asks, well, based on what we're told about these class members, we ask what would their perspective be? That's what the tribunal is saying here. They're saying we're going to take a notional class member based on the class presented to us, which is homogeneous, the tribunal recognises, and say, well, what's reasonable? Sorry?
Is homogeneous.
The class is, sorry, no, forgive me, the class is heterogeneous. There are lots of different types of class members. I'm so sorry. The tribunal recognises the heterogeneity of the class, as we'll see later. And when it says we're looking at reasonable class members, all they're saying is we don't have actual people. So we ask ourselves, what do these class members really face in terms of practical obstacles? Big banks, hedge funds, pension funds, import-import companies, export-import companies using FX dealers. Those are the reasonable class members that we had in mind in asking, do they face practical obstacles?
This is just a rather dangerous rhetorical flourish, the reference to the Clapham Omnibus.
I think
when you add up what the majority have taken into account, it's subjective, objective, it's perception of class members, perception, you know, their view of life. I mean, it's everything under the sun, which isn't that dissimilar to the way the minority, Mr. Lomas, put it. He said it's neither objective nor subjective. You just look at all the facts in the round. That's more or less what we said in the Petterell. It's a mixture of factors over which the CAT has a reasonable discretion, and it's hard to really classify it as subjective or objective.
And when we come to, I respectfully agree, when we come to see what the CAT actually did, we see that's what they did. This may be an unfortunate rhetorical flourish because it suggests they're looking at one notional person. And that's not what the tribunal ultimately had before to what it did. So we go on to now on page, the next page, 296. And this is the very point that we've been discussing. Little 6. In some claims, the class may be diverse, claims of different sizes, very different sizes, varying degrees of knowledge, experience, so that for some members, the practical bar often may be higher. The question arises in these cases, how to test practicability. It seems to us incumbent on the tribunal, when considering practicability, to have regard to differences in class composition, not to allow the fact there are some members who are clearly able to decide for themselves about opting in to override the interests of other members for whom opting in is not practicable. So it's a very fact-sensitive question. So I should have taken to this paragraph when I was discussing it with my Lord Justice Green. They had the proper approach clearly in mind, and that informed then what they go on to do in page 436. I'm going now to 434, sorry, 434 of the judgment. Page 434. And the tribunal refers to the Ramirez evidence I've shown you, and it
refers to the different types of financial institutions and non-financial customers. Then he says, the tribunal says at little 4 at the bottom, the class composition assessed by Mr. Ramirez are fairly large and inferentially sophisticated institutions.
Sorry, which page are you on?
I'm on page 434, by the way, the very bottom of 434. So he recognises, he has referred expressly to the Ramirez evidence that notes the differences between the classes and the exclusions which Mr. Ramirez applied. The tribunal refers to the volume of commerce over the page at 435. And it says, they say in terms, the tribunal, in 435, on page 435, sub 5, although there's an average, they say, given the diversity in the class, an average may be more misleading than helpful. And they refer then to the average figures given to the tribunal by Mr. Ramirez. These were average figures presented by the PCRs to the tribunal. And then in analysing that table, the tribunal says, the penultimate line on page 435, we repeat what we say about the danger of averages. Now they say these figures don't take into account the potential for a pass-on defence, which they go on to address, but they recognise that they're dealing with averages. They haven't ignored the heterogeneity of the class. But they do note that on any view, on average, they are significant individual claims, and large institutions would have the potential to claim really quite large sums of money. And this is important, little 7 on 436. We're not dealing with a merits type claim. Whether the claims are so small, you can see why they would simply not be interested in signing up to a claim. That's not this claim, the tribunal finds on the facts. Little 8, the putative class members in this case, across all their different heterogeneity, will, on the whole, be sophisticated potential litigants capable of looking after themselves, certainly where their claims are of value. It's absolutely the case with the Evans PCR class, where Mr. Ramirez has made clear he's excluded from his analysis the smaller entities. And they'll come back to that exclusion. And they say then at 9 that many of the large people have been approached. They're not in ignorance. It's not ignorance that's preventing them from rushing in. It appears from the evidence that the PCR has explained to the tribunal to be a deliberate decision. It may be that they're not impressed by the claims, they don't want to be involved. They may be apprehensive because of reaction, but the tribunal found as a matter of fact, and I'll come to that, the evidence didn't make that good. But the key point is there's no reason why it's not practicable for them to join in. There's no practical obstacle to joining in. And in fact, when they look at the reasons appear to be for not joining in appear to be other than reasons going to practical obstacles. And that was all based on detailed factual analysis by the tribunal. And now going, if I may, to 10. So they noted the point that Mr. Ramirez had excluded a much larger group, which would bring it up to 100,000 people. And that's a much more diverse group. And as Mr. Ramirez said, many of them may have never dealt with FX dealers. Mr. Ramirez said it was speculative. And at the very bottom of little 10, they say, it may not be practicable for them to opt in, but we shouldn't allow a subclass like this, whose total claims would be a tiny fraction of those of the whole claim, to change what is a clear-cut conclusion on practicability. And I would add to that, a further reason why the tribunal was entitled to reach that view was because even on the PCR's case, they were not offering that extra tail as part of the proposed class for certification. They were reserving their rights to do it. And the tribunal was well within its rights to do it.
Sorry, I didn't hear what you just said.
I'm so sorry, my lord. A further reason, I don't think it's said here expressly, is that this extra tail of class members that the tribunal said would be the tail wagging the dog were ones which Mr. Ramirez had not actually put forward as part of the class composition in his evidence. He was reserving his rights to add them. They were not part of it.
I misunderstand it. As defined, the class would include anybody, as I understand it, who had a deal with the respondent banks, so that the very small one-off person with a tiny numerical claim would be within the class as defined. It's just Mr. Ramirez didn't, for the purposes of his evidence, respondents.
I entirely misspoke, my lord.
Well, no, I know you do, but
that was a
I'm
mistake.
just, I just want to understand this.
I misspoke because you're quite right. They would be included. The point was that that Mr. Ramirez wasn't relying on them to justify, and the PCRs weren't relying on them to justify certification. And the tribunal said, we see that, but we regard that diffuse group upon which so little reliance was placed as not sufficient to alter our conclusions for the rest. I think I'm putting it no higher than that.
Okay, but then in the last sentence of 10, I mean, the CAT only says that because it treats as the determinant the question of the value of the claims. It talks about a subclass of persons whose total claims will be a tiny fraction of the whole class. Therefore, you identify them as the tail wagging the dog because the dog is a value dog.
Yes.
If the dog was a numbers dog, that subclass would be the dog, wouldn't it? Not the tail. So I think it was once said, recourse to canine analogies doesn't actually help very much, and it was said when I was standing in your position at one of my submissions, I think, to be fair. So I won't repeat my error, but since it's there, I mean, that whole point about what you disregard just depends upon the assumption that value is the key question, doesn't it?
No, and I've also been told, standing in this position, to avoid any analogies at all. So
I think Lord Wilberforce was who said all analogies are dangerous.
somebody said that to me more recently than Lord Wilberforce. But on the point, it was not the key determinant. He refers to it here. He notes that their total claims to be a tiny fraction of the whole class. But my understanding of what he's saying here, this is a factor weighing in favour of opt-out. He's assuming this could be a factor in favour of opt-out, but it's massively outweighed by all the other factors pointing towards opt.
Well, that chart that we were looking at of Professor Ramirez's at the end of his report, and I put to you the 15,000 with a turnover less than 500,000.
Yes.
An average claim of 15,000. If I know that's the financial institute, they're the smaller end. And I know you don't. I know you say all of those people should be in an opt-in regime, but let's just assume, for the sake of argument, that they form something like 40% of the total class in terms of numbers. And you couldn't, by any stretch, describe that as whether the analogy is a good one or not, as the tail wagging the dog. I mean, it's a very substantial proportion of the class, which I think is my lord's point.
I think with respect, my lord, you're making different points against me. The point that you made, my lord, is that I'm wrong. The tribunal was wrong to say that even for financial institutions with large turnovers, suffering small amounts from their perspective, £15,000, that they should have been included in an opt-out class. My answer to that is the tribunal found that they were sophisticated, informed entities who had no access to justice problem and could easily throw their name into the ring for an opt-out claim and get the 15,000 if they were being prudent. The point put to me by my lord Snowden is a different one, which is here these are people for whom there may be an access to justice issue so small, small enterprises, they may not be well informed. The tribunal didn't find these were sophisticated, well informed entities. But Mr. Ramirez's evidence, which I took you to, was that it was speculative as to whether people that small traded FX with these dealers at all. And because Mr. Ramirez said it was speculative, and his own evidence, the tribunal was entitled to give it less weight and not to allow that to override all the other factors which the tribunal found pointed towards opt-in.
That's a slightly different point than saying value is the determinant.
Yes. But he didn't say their, sorry, they didn't say their value was the all and end all. I say that was a factor. I appreciate they referred to it, but my submission is that you need to read that in the context of the whole judgment.
And just give us the reference paragraph number would do too, where the tribunal said that this aspect of the claim, the small numbers, were speculative.
Mr. Ramirez said that in his evidence.
No, the judgment, where the CAT took that into account. Did they take it?
I don't see that. I didn't see that in the. So let's look at the Ramirez reference to speculative. I gave you when I went along. Somebody will give me back.
I suppose is it footnote 199 slightly at the top of the page? It's far further up that sub-paragraph.
Yes.
footnote 199, isn't it? It's the reference to footnote.
Yes, indeed. I just can't remember what paragraph 69, 69 is the, oh yes, that was the paragraph indeed, where Mr. Rivera said, among other things, it's speculative. Thank you, Michael. Yes, that's right.
Yeah.
That's the paragraph.
Which paragraph?
Paragraph 69
Of Mr.
of
Ramirez.
Ramirez 1, and it's footnote 199, I'm grateful, in the judgment itself. So I will, if I may, speed through the rest, because the next, that's it on, sorry. That is it on the detail of the judgment. And so now I'll move quickly through the outstanding complaints that the applicants make about the judgment itself. They say the tribunal ignored default effect, the theory that class members would view opting in as more significant than opting out. But the tribunal, we say, considered all of that evidence. And all of it is cited at the end of the judgment from page 479. There's no need to turn it up. They list all the evidence they considered. It's not appropriate in my submission to criticise the tribunal for not citing each and every bit of evidence that was put to them in this case. The judgment is long enough without complaining about that. The applicants then, so the appellants complained the tribunal didn't deal with certain points made in their factual evidence. We say they took them into account, and if you look, I'm not asking you to go to the evidence skeleton, but just taking in turn the points they raised there. They say that the tribunal didn't take into account the evidence in Mr. Ramirez that some class members wouldn't opt in because the returns wouldn't justify the costs. The tribunal dealt with that, and you see where they have addressed it. The evidence skeleton says that it wasn't straightforward to identify class members. Now, the tribunal did identify that there was an administrative burden in identifying class members for opt-in, but that it wasn't particularly difficult for these class members. Just for your note, it's paragraph 372 sub 5 of the judgment, for two reasons. First of all, the one given by the judgment, which is these are sophisticated entities that can identify themselves, the point the submission I made to my Lord the Chancellor, but also, for your note, Mr. O'Higgins' first witness statement says in terms that the class members are easily or readily identifiable. And that's in the big bundle, the one not in hard copy, supplemental bundle, page 1424, paragraph 24. And as regards to the fear of retribution, reference was made to Mr. Mitchell's evidence. But before I get into that, the tribunal will know, sorry, the court will know better than anyone, that litigation of this type is a fact of life for large banks. The idea that in an opt-in action with hundreds or thousands of class members, there's any realistic fear of retribution from the banks which are defendants is simply unreal. It didn't deter the hundreds of entities that sued us in Allianz. It wouldn't deter, if the claim was sufficiently good, the hundreds of class members with claims worth £2 or £3 million in this case.
Retribution is a sort of nice word to sort of use to label this, but it covers also the fact that you might have if you are engaged in conscious litigation to break your relationship.
The tribunal considered this issue.
Yeah, but that's under your heading of retribution, isn't
Yes,
it?
indeed. No,
Which is a different, it's not retribution in any sense, it's part of the label.
Indeed.
It's a disruption to business relationships.
And if taken to an extreme view, it might even be raised as a practical concern. If there was if someone was genuinely concerned, deterred from bringing a claim because they were dealing with a very powerful entity with, it could, depending on the facts, lead to practicability issues. And this was raised before the tribunal. And the tribunal looked at the evidence that O'Higgins had raised, Mr. Mitchell's statement that my own friend Mr. Joel took you to. Mr. Mitchell's, I'm not going to go back to that, I'm just going to give you the references in view of the time. Mr. Mitchell said there that he was using RBS as a prime broker for his company. He said he was worried in the United States about opting in to take his share, but he went ahead anyway. He continued trading with RBS, and he spoke in paragraph 22 about worrying about antagonizing RBS, which he needed. But then he goes on to say how he joined the advisory committee of the PCR against the banks in September 2019. And he's given evidence positively against the banks in these proceedings. And that's the best evidence that the applicants can produce of a class member being concerned about rupturing commercial relations with its bank. This is a man who went on the record and was on the advisory committee, and all the while using RBS's services. He said he was winding down his business, but he was using RBS's services all through this period. And the tribunal was entitled, having reviewed this evidence, to say, we just don't think you've made it good that in an opt-in, these sophisticated, well-informed financial institutions and corporate bodies would be concerned to the extent that opt-in is not practical. The point was made about funders. Again, when you look at the funding evidence, it's very carefully worded. True it is that they are proposing funding for the particular opt-out application put. And although the funders say we wouldn't fund an opt-in, when you retire and look closely at that funder's evidence, it's very carefully worded. The funders, we say, should have no problem funding a viable opt-in action if those large entities which have no practical obstacle opt in, and they would provide momentum. The case would be eminently fundable. But overall, my core point is the one about access to justice. I'm coming now to the end of my submissions. It would be extraordinary, I say.
Sorry, just before you end then, I may have misunderstood the submission that was made. It's quite possible. I understood something to have been said, I think by Ms. Wakefield, to the effect that funders prefer opt-out because there's a much bigger chance that there's a pot of unclaimed money left at the end of it that funders can in some way have access to as part of the arrangements, whereas if it's opt-in, in a sense, you're funding a class of people, all of whom are alert enough to have opted in and therefore will claim what is the pot at the end of the day. I mean, did you have any observation on whether that's right and how that plays out?
Two points to make. First of all, we don't accept even on its face that that's right, because the funder's own evidence before you is they fund group litigation cases. They fund other opt-in cases with great success. And I was waiting for Mr. Perslow's evidence, thank you. Let's take it up since you asked me the question. It's in Key Documents, tab 33. Key Docs 33, volume 2. Page 2394. Yep. Mr. Perslow's explaining the other things that they've funded, Ethereum. And at footnote 3, he refers to, this is all about explaining how experienced and competent they are. They also fund the group litigation order in Lloyd's HBOS, and the VWNOX emissions group litigation. Now these are all opt-in, massive opt-in issues. That, as I said, that VWNOX emissions group litigation is a very considerable thing, and it was funded without, as far as we know, anything like the residual payment for funding which exists under the opt-out regime. But the second point on why it shouldn't be determinative is that
Sorry, I think somebody wants to.
Sorry, just because the issue that's being explored at present is my submission, I think, in relation.
If I may have misunderstood.
No, absolutely. I think perhaps I made it rather badly. So the position is this, that for an opt-out set of proceedings, the way the funding model works, and the only way that it can work, is for the funder's return to come out of undistributed damages. One's not in any kind of retainer or contractual relationship with the class members, and the class members get their damages entirely devoid of any of the associated costs of obtaining those damages. So the funding model depends, and by statute needs to depend, on the existence of undistributed damages. So that means that if one has a class where everyone will opt in, or everyone will come forward at the end to claim their damages, those proceedings can't be brought, they can't be funded on an opt-out basis. And so those proceedings would need to be brought on an opt-in basis with conventional retainers, conventional funding agreements, in order for them to be funded effectively. So in a sense, my submission was almost the opposite of the submission I think that your Lordship may have understood me to make, and I apologise for that. So a funder would prefer, for a highly engaged class, for those proceedings to be brought on an opt-in basis, because for that highly engaged class, on an opt-out basis, the funding model wouldn't work. Because
If it's
they'll
a
all come
highly
forward
engaged
again.
class. If it's a highly engaged
Absolutely,
class.
absolutely, my lord.
The risk
Yeah.
is relatively low because the chances of there not being some degree of undistributed funds is relatively low.
It is low, certainly in opt-out proceedings in general, but if one has the class of 50 very engaged individuals and undertakings, one has their email addresses, all the points I made on day one. So that was the point I sought to make. I apologise that I was unclear.
So the point I was making, of course, was a different one, which was how would one fund an opt-in action? If a point was funders might prefer opt-out, and it's true that in an opt-out action, that's how they get their cash. But opt-in can also be attractive for funders, which is important for viability, as I think Ms. Wakefield accepts. And these GLO cases are a perfect example of that. In an opt-in case with big value claims, it's well worth the funder's while. Then,
Sorry, which case?
sorry?
Which case is that?
Lloyd's and H
No, the VW, the one I mentioned.
The VW one is in the general.
It's a group
King's
litigation
Bench
order.
list, isn't it?
Yes, it is.
So it's a group litigation order, so it can only be opt-in.
Exactly. And that's why I was.
So they've got to do, if they're going to fund it at all, they've got to fund it on an opt-in basis.
Indeed, but the point is, if it's being suggested,
They have a choice.
if it's being suggested that
Simply, they are in principle viable.
opt-in cases are in principle viable for funders and have been proven to be so in
Well, I
the
don't
GLO
think
context.
that this witness statement suggests the contrary, does it?
Oh no, I was relying on it because it was being said that without opt-out, you're just not going to get a funding arrangement. This thing will die because of a lack of funding. That's not right. Right. And then so yes, I was coming finally to the end, and I was making the fairness point that about access to justice, that it would be extraordinary if the opt-out regime designed for consumers and SMEs was used to bring in hundreds or thousands of sophisticated financial institutions with huge turnovers of their own, claims worth between £2 and £3 million, where there's absolutely no identified problem with access to justice, except the finding that for reasons unconnected to access to justice, they don't have an interest in currently bringing these claims themselves. And that would be directly contrary to the purpose of legislation and indeed all of the pre-legislative material upon the architecture on which this regime is founded. And in terms of the tribunal's own assessment and the recognition this court should give of its own expertise, Professor Newberg, I'm told, is the Professor Emeritus of Finance at the Bayes Business School, Faculty of Finance. He was obviously in the majority in the tribunal. And we will tell you that his research interests include option pricing and hedging and market microstructure. In 2021, he published an article, The Cross-Section of Currency Volatility Premia, in the Journal of Financial Economics. If my friends want to respond to that in writing, I'm sure they'll forgive me for ambushing them with that piece of evidence on that issue. So Professor Newberger, to answer the short point, is an expert and has experience in relation to financial markets. But more importantly, the tribunal undertook a very extensive multifactorial assessment involving the exercise of predictive judgment and the consideration of a vast amount of evidence. And whatever concerns the tribunal has about the decision or the judgment, that factor is highly material to your consideration as to whether any error of law occurred in this case. That is the last point that I'll leave you with. That's central to the approach this court should take in how you handle this judgment. Unless I can further assistance, or unless I'm told to add anything to those submissions.
Sit down quick before my lord asks for another question.
Thank you very much.
Thank you very much.
My lord, we're going to follow the same broad division of strength and practicability, but in reverse order in apply. So as to follow broadly the order of Mr. Kennelly's submissions. I would like to respond on, I'm going to go broadly speaking chronologically through the key points, and of course not everything. But I'd like to respond on two issues at the outset that I apprehend your lordships may be particularly interested in, namely the availability of data to calculate the spreads of non-respondent dealers and the application of the Hollington and Hewthorne principle to sterling lands. Now, Mr. Kennelly took you to part of Professor Breeden's evidence, in which he observed that there were a number of limitations with certain of the public sources of data on non-respondent trades that Mr. Ramirez proposed to use. And on that basis, it was suggested that neither PCR will be able to make good our case in relation to spread widening on trades with non-cartelist dealers. And it was suggested, I think, that that was what the tribunal had in mind when it spoke of the case not being capable of being tried. And I wish to make 2 points in response to this. The first is that, quite simply, when you read the evidence as a whole, it is clear that there is actually going to be ample data on the basis of which it will be possible to calculate spreads with non-respondent dealers. And as I said yesterday at closing, I must issue a mea culpa, because when I was asked about this in the course of my submissions, I really didn't do justice to Professor Breeden's extrapolation approach and the nature of that. And what I'd like to show, if I may, is that there are a number of sources of data. If I could take you to the evidence and start, please, with the first supplemental bundle at tab 20, where you'll find the first witness statement of Ms. Holway of Scott & Scott Solicitors, and this went with the very first application. And you'll see on page 1442, at paragraph 3, that she mentions that Scott & Scott was the co-lead counsel in the US foreign exchange litigation, and the US proceedings are class action proceedings which allege that entities from 16 banking groups caused loss by breaching US antitrust law. So this is the US counterpart. And she notes that it's highly likely that some members of the proposed class are also members of the class represented by the plaintiffs in the US proceedings. Mm-hmm. And if you look across to paragraph 7, you'll see that she mentions that there's a protective order akin to a confidentiality ring in place in the US proceedings that prevents, for the moment at least, the use of confidential material in those proceedings. But everything that she says is based on publicly available information. And if you go forward to, please, to 1453, you'll see on paragraph 16, she notes that during the course of the US proceedings, the US had produced very large quantities of information and data. And she notes that the following had been disclosed. Documents, 1.6 million documents, transaction data, the US defendants, so that's all 16 of them, produced over 7,000 files of transaction data from over 30 different trading systems, amounting to approximately 10 billion rows, and third-party transaction data obtained pursuant to subpoenas from non-party sources, including Hotspot, Reuters Matching, EBS, and Reuters. So there is a veritable treasure trove of US data there that is likely to be available, and it will be available in respect of 11 non-respondent dealers, because only 5 of the 16 are respondents. And then if you look on in this witness statement, you'll see paragraph 21 on page 1454. You'll see that she has been, in conjunction with Professor Breeden, seeking to ascertain what data is available on trading by UK domiciled entities. And she notes the NEX, formerly EBS, Refinitiv, formerly Reuters, Bank of England, Euromoney, and the Bank of International Settlements. And then in paragraphs 24 to 25, you see she notes the experience in the US proceedings indicates that the proposed defendants hold detailed and voluminous documentary and transactional data, which I anticipate they would be required to provide to the proposed representative and its experts by way of disclosure in due course if a CPO is made by the tribunal. there is no reason I am aware of to think that the proposed defendants would hold any less detailed data in relation to the proposed collective proceedings than was produced in the US proceedings. In addition, should it prove necessary, the proposed representative could seek equivalent transactional information from non-defendant banks or from other organisations with relevant data. So it's been recognised right from the outset that there's a potential for third-party disclosure as well as this enormous volume of data from the US proceedings. Now, Professor Breeden refers to this source of US data, and I'll come on to that. But he doesn't just assume he can use it, because there is the protective order. And so instead, he devised a different method, at least initially, to extrapolate from the data that he knew he would get. But it is, as I said, important to understand the nature of the extrapolation. And I confess that I forgot the details when my Lord Justice Snowden asked me about this, I believe. But if I could invite you to go, please, to volume 3. It's at tab 52. And if one goes to 3162, now Mr. Kennelly took you to the later, 1.5 pages later, but the critical part is really starts at 5.8, where he notes Mr. Ramirez's criticism that his extrapolation is not a viable methodology.
So where are we?
Forgive me. This is third volume of the.
I've got that far.
Yes,
Paragraph 5.2.
5.8.
5.8.
5.8, my lord. Page 3162. And you'll see he cites Mr. Ramirez's arguments against his extrapolation methodology. And then he explains it in more detail. And he says, in contrast, Mr. Ramirez claims that he proposes a methodology to measure the harm on non-respondent transactions which doesn't rely on depend on obtaining proprietary transaction data from these banks. And he notes that he intends to use electronic trading platforms and settlement data. He says this, paragraph 5.10. As a preliminary point, I note that being limited to respondent data does not mean that I do not propose to test for differences in the harm per trade of cartel trades and non-cartel trades, as suggested by Mr. Ramirez. In my analysis, I expect to receive respondent data over the whole infringement period and the clean period, despite the fact, the clean period is the period after the cartel, despite the fact that not all respondents were a member of a cartel over the whole period. In fact, as Appendix 2, reproduced from his first report, indicates, if I were to receive data from all respondents over the whole infringement period, over a quarter of my sample would be for non-cartel members. Indeed, this varying membership of the cartel represents one of the many reasons why he says the single collusion dummy per model approach described by Mr. Ramirez is not appropriate. Since this source of non-cartel data would be in all other respects very similar to cartel data, and over the same time period, it provides a good source from which to test for differences between trades with cartel members and non-cartel members, using dealer and time interaction terms as discussed previously. Indeed, I consider it a superior data set to the one proposed by Mr. Ramirez to test for the same effect, for the reasons I outlined below. Now, just if I could just show you the table that he refers to, because we don't unfortunately have the appendix, but it is in the it's in his first report. If you go to first.
We need to keep this open, or
Yes, I think if you wouldn't mind. But if you go to please to the first the first of the supplemental bundles, to right at the back to tab 22, you have his first report. And if I could invite you to go to page 1622, you'll see you should see a coloured diagram.
Yep.
And what he's showing here is what Mr. Kennelly also referred to, which is the intermittent nature of the various cartellists' participation in the cartel. And you see the coloured bits are where a particular bank participated, and the white bits are where they didn't participate. And so the point he is making is when they're in at least 25% of the time, a bit more, they are entirely out of the cartel. So during that period of time, they are effectively non-respondent dealers because they are not liable under the terms of the decision, and they are not participating in the cartel. And so it's a very good way, he says, to proxy what it is a measure of what non-respondent dealers' spreads are, and it's a very good proxy for other non-respondent
It
dealers.
assumes as a fact that during the white periods they were outside of the cartel, and I notice in the Commission decision, the Commission says that they're only finding for the period for which they're certain, they don't preclude the possibility. But I understand the point.
Yes,
I mean, this is you'd say a matter for trial, as it were. You'd have a look at the
Yes.
data to see to what extent there were differences.
Yes, yes, indeed. And if one goes on, he then, if you wouldn't mind going back to his
Second.
go back into his second report at page 3163.
But your short point is that even for respondents, they were at various points in time non-respondents, so that within the data set you would obtain by disclosure in the ordinary way, you would get periods which you could use for your regression, your comparative regression analysis.
That is precisely his point.
That's the short point.
Precisely his point. And it's very ingenious, and it's a way of saying you can measure the non-respondent spreads from there.
You could benchmark that against other
From
sources
there,
of
yes.
data and so on.
Exactly. But he doesn't stop there, because if you look at the next paragraph of his report in 5.11, he says, in my amended first report, I was conscious that I would need to describe a methodology that could be applied relying almost exclusively on data supplied by the respondents. This is because the scope of any disclosure orders in the litigation post-certification are currently unclear, and it seemed safest to assume that I might have to rely on the respondents' data. I hope to use non-respondent data in my final analysis, with perhaps the most promising source being the data currently being produced in the US proceedings, which I hope will be available in a form that allows me, after some adjustments, to integrate it into my model and estimate using an extended sample of trades. And he notes that that some materials from the US proceedings had been disclosed in the Allianz proceedings. And then, as you've already been shown, to a degree at least, he then goes on to discuss the various data sets that Mr. Ramirez identifies, and at least one of them, the Reuters, is the same as the data set that Ms. Holloway identified in her first witness statement. Now, Mr. Kennelly highlighted the points where Professor Breeden notes the limitations of these various sources, but that's, of course, that's not a criticism of Mr. Ramirez. I mean, he is not, after all, an FX microstructure expert. He is an economic consultant, and to be fair, Professor Breeden notes that these sources may also be useful for some purposes and could supplement the model that he and Professor Bernheim proposed to run. And Professor Bernheim and he have also obviously been considering the use of this type of publicly available or potentially purchasable information for various things, for measurement of the mid-market price. And you'll see that he cross-refers at the footnote 126 to Professor Bernheim's first report at paragraphs 126 to 129. Now, I'll go to that, but if I could just, so as you don't have to keep jumping back and forth, one then sees the conclusion that Mr. Kennelly read out, which is that he notes in 5.15, he says, my analysis can be carried out without access to any third-party data if need be, though I may be able to make limited use of some third-party data sets for some purposes as described above. To the extent that I require third-party data for the purposes of my analysis, I understand that it may be possible to obtain via third-party disclosure or in the case of Reuters' Refinitiv purchase. So it's a much less pessimistic picture than I think had been portrayed to you. And if I could invite you to have a look at, just briefly, at Professor Bernheim's report. If one goes to the second supplemental volume at tab 23.
So for example, so in relation to the defendants, when you get the non-cartel period, what you're essentially looking for is to see whether the spreads alter. So you can do a comparison of spreads during and before and after cartel periods.
Yes, exactly. But if one looks at Professor Bernheim, I think I maybe need to come back to this report. Well, I may take you now through it in a little bit of detail, but let's first of all, if I might, just show you those particular paragraphs that are cross-referred to by Professor Breed. Once that goes to page 1801. And you'll see
I'm so sorry, can you just get me the reference
yes,
again?
it's tab 23 of volume 2 of the supplemental bundle at page 1801.
Thank you very much.
126.
Yeah. And you see he notes the construction of effective half spreads and realised half spreads will require information on executed trades, as well as data on bid and ask prices that can be used to construct an estimate of the market mid price prevailing at the time of each trade and at points in time after each trade. And it's reasonable to expect that this information will be available. In particular, and he notes, data on executed trades will be available from the defendants. This will include information such as the counterparty, the type, the transaction date and time, the transaction price, amount, currencies, and potentially other details. And information on bid and ask spreads will be available from interdealer platforms, for example, Reuters, now Refinitiv, and EBS. Though again, the same public sources that Mr. Ramirez and prior to that, Ms. Holway had identified. And he says, I've reviewed samples of data from the platform, and they include, and then he mentions all of the various parameters that they include. The point that he if one just perhaps I should point this out now while we're on it, but Mr. Kennelly, in relation to one paragraph in the judgment, said what the court was after, what the tribunal was after, was a model, and we didn't produce a model. And I was very puzzled by that, because if you look at Professor Bernheim's statement, one goes to, for example, we just sort of track it through. If you go to page 1787, you see paragraph 79, and he starts with a simple dummy variable model, which he sets out mathematically and explains. And then if one goes to page 1792, paragraph 92, there he says the dummy variable method can also accommodate the possibility that the cartel's effect varied across different types of transaction. For example, in the context of FX transaction, the impact might differ for trades conducted during FX benchmark fixing. Says this can augment the single dummy variable model to include additional dummy variables, or as well as an interaction term that consists of the products of the cartel and the benchmark fixed dummy variables. And he gives another equation. And then if one goes further through it, one sees he then talks about the selection of explanatory variables, data aggregation, and by the time we are then on to page 1799, we see proposals for how to express the realized half spreads and the effective spreads in mathematical terms. And so this is, in effect, not a complete up and working model, but it is a description of the model he proposes to use in really very elaborate and careful detail, down to the types of data that is going to be used for each different type of explanatory variable. And it's
what does this boil down to? You say you have what the tribunal accepted was a plausible economic theory.
Yes.
you went further and you identified the sources of data that you would rely upon both for
Yes.
everybody, Class A, Class B, or everybody.
Yes.
And you had identified a model theory that you would apply to that data, which enabled you to analyse both periods of cartel infringement and non-periods of cartel infringement.
Yes.
Then you say that would generate the data, which would enable you to determine whether both effect within the Class A and or
Yes.
to see whether and if so to what extent there was a ripple effect for umbrella.
Yes.
And then the tribunal effectively says, well, that's theory, we want some more, to which you then say, well, we can't until we get the data.
That's precisely the
Which is
dilemma.
exactly the point that we made in Goodman.
Yes. Except if I may add,
Absence of disclosure of paragraph 55.
yes, except I think it's fair to say that the level of elaboration of the model in this is far beyond
Necessarily is limited at this stage.
Yeah.
But in accordance with paragraph 54 of Goodman, has identified what the sources of data or evidence will be that will support
Yes.
economic theory, thereby demonstrating it's not merely theoretical.
Yes. And done it in really.
And whichever
Yes.
class representative is the right one, that's a point that applies across the board really to both class representatives.
It absolutely is, and it's important not to exaggerate the distinctions between these two claims. There is one important distinction that I'll come on to, which relates to the type of transactions that they managed to capture. But if one turns to, for example, to page 1808, at the top of the page, one sees Professor Bernheim reflecting on the division between Class A and Class B. Now, of course, it's quite a notional division because, in this sense, that these are not two classes that have got separate class representatives or anything like that. And effectively, they're just notional subclasses. And the point that concern, and of course within the O'Higgins class, there is both Class A and Class B. They're just put together. And the point he makes, you see in paragraph 138, is that he says Professor Breeden's proposed use of models with multiple dummy variables allow him to accommodate concerns that the cartels may have had different effects on different subgroups of trades, possibly through different mechanisms. His approach has the considerable advantage of exploiting the fact that all transactions are disciplined to a significant degree by the same market forces. Now, Mr. Kennelly would agree with that. He says it follows that analysing all transactions together while allowing for appropriate dimensions of heterogeneity in the measured effects will enhance accuracy, precision and reliability. Professor Breeden's approach is also more flexible in that it permits him to reach conclusions about the heterogeneity of the cartel's effects based on the patterns in the data rather than based on preconceptions concerning the important dimensions of heterogeneity, which are which of necessity relatively uninformed at this stage of the analysis. To put another way, I suppose you could put it this way, that one sees a very sort of obvious distinction between trades with the cartelists and trades with the non-cartelist dealers. But it may well be that actually, really the big difference isn't between those two. It might be, say, between voice trades and e-commerce trades, or it might be between one currency and a different currency, or it might be between benchmark trades and immediate orders. One just doesn't know at this stage of the analysis, and that's why the O'Higgins approach is always just to wait and see before subdividing them.
We're, I suspect, going to have a look at this in slightly greater detail this afternoon. So I'll just say,
Yes.
as I understand, one of the big differences that Mr. Kennelly identified between what we just call for this purpose Class A and Class B
Yes.
is that the effect of the dealers' behaviour within their own institutions is factually driven by lads in the dealing room, for want of a better expression. You know, how there's a ripple within the institution,
Yes.
as a matter of fact, and there's some evidence about how that happens.
Yes.
But once you go outside the cartel institutions to the wider market effect, how does that affect trades between a member of on this footing Class B and a non-cartel bank?
Yes.
You have to rely upon another factual factor, which is, I think, identified as the is it ASL?
Yes, adverse selection. Yes.
Adverse selection risk. I think
Yes.
I got the
Yes.
acronym right.
Yes.
And Mr. Kennelly says, well, actually, that's just nonsense, because why would non-cartelist banks raise their spreads?
Well,
They would naturally,
yes.
it's obvious, he says, look to undercut. And so you do have a factual factor. Now, we can debate it's a question of the strength of that factor, but that's not a statistical factor, is it?
Well,
It's something which potentially differentiates Class A and Class B through non-statistical. It's not a statistical question; it's a factual question. How does putting Class A? I'm just putting this question.
Yes.
How
No,
does
no.
putting Class A and Class B together gloss over that big factual dispute that exists?
Well, in a sense, putting them together doesn't matter, because you'll run the regressions and you'll see whether there's a differential effect on the respondents dealers and the non-respondent dealers. So the fact of them being notionally a single class or notionally two classes is really neither here nor there. It will be detectable by the methodology of looking at whether the spreads widen or not. Now, the difference between there are effectively both parties, and I'll try to describe this neutrally as I can. Both parties rely on two mechanisms. That the one is, as you said, is what they call the direct harm, and the other is the adverse selection risk. But it is important to appreciate that both parties also rely on both of those mechanisms as affecting both of affecting both A and Evans A and Evans B. And the reason for that is because it's because it is a single market, and the effect, the adverse selection risk causes losses, as I sought to explain in opening, to the but as on the interdealer market, and those losses force effectively the non-respondent dealers to raise their spreads, which effectively their prices, because otherwise, as Professor Breeden explains, they will go out of business. And that comes back to affect the ability and the efficacy on Class A, because absent that, one has a relatively small market share of the colluding dealers, and unless you also have this allied effect on the non-respondent dealers, then they're not going to be realistically able to expand their own spreads. At least that is the view, certainly, of the O'Higgins experts. And so but both experts accept that it is the combination of both, but both effects will have a combined effect upon Class A. So Class A. So
on those who dealt with the
yes, exactly. And the way that I cross-examined.
Just
yes.
Just to understand the
yes,
point.
Yes.
I mean,
So,
what Mr. Kennelly said is that, this is all very interesting, but of course, what would in fact have happened in relation to people dealing with the non-respondent banks is that the non-respondent banks will have undercut the respondent banks. And therefore they haven't, I think where that goes to is saying, well, that the people who dealt with the non-respondent banks haven't suffered a class-wide harm. This is all just an economic theory.
Well,
As I understand your point to be, and sorry, I'm putting this in a very simple way.
no,
But
it's
your
complicated.
point to be that
Yeah.
that none of the colluding respondent banks, none of the collusion would have gone on if that had been what the consequence of it was.
Correct.
Because it makes no economic sense. Well, it makes no commercial sense for the colluding traders to do it. It may on the individual trades,
Yes.
but or the first set of individual trades. But the next time round, if everybody else is cutting them, undercutting them,
Yes.
they're not going to get the business. So they'd be saying to themselves, well, hang on, lads, we really shouldn't be bothering with all this. We better go back to where we were before because we're all being undercut.
That's right. It might be different if they were like 90% of the market,
Yeah.
but
I
they're
follow
not.
that.
They're sort of.
Yeah.
But Mr. Calendi's right about that, and that's why it is a combined effect. And Professor Ryan, basically, he accepts this. I mean, he doesn't suggest there's not a combined effect
No.
on Class A. He called it, when I cross-examined it, he called it a feedback effect, I think, at one point. So he says, and the difference between the two sides on the causation of harm is really ultimately a matter of emphasis.
So
So-
when you say different between two sides, do you
Forgive
mean
me, the two PCRs, yes. So it's really a matter of emphasis. So our experts take the view that the central mechanism is the adverse selection mechanism. Now, I appreciate that is not as familiar a mechanism to this court or indeed to many people, but it is a very familiar mechanism to those who are expert in FX microstructure. One sees that recognised in umpteen articles, and that effect is the way it operates is by costs. Effectively, when the non-respondent dealers, the non-participating dealers, go into the interdealer market to lay off trades, to recoup inventory, they are intermittently stung by the collusion of the participating traders. And that imposes a cost upon them. It's called adverse selection risk. In fact, when it's at home, it's just, these are higher losses that they make. And because they make higher losses, they can't then continue in business, or they can't certainly continue in business making the same amount of money. So they seek to put up their prices, and their prices are their spreads. And meantime, the colluding dealers are then able to continue with their collusive activity under the umbrella, effectively, of the higher spreads that they forced on the non-colluding dealers. So so it's two mechanisms then that come in and interact to create the effect. And it's the difference, as I said, the difference between the professors is really more one of emphasis than anything else, in the sense that Professor Breeden and Professor Bernheim consider that it's really it's the principal mechanism is adverse selection, and the collusion is contributory. Whereas Professor Rime likes to say, well, they're both, if you like, both causal mechanisms, and they interact. It's a very nice sort of distinction that actually, when it all comes out in the wash, nobody will probably ever be the wise as to whether it's contributory or primary. So forgive me for that that sort of expedition, and this is it's a complex theory, but doesn't mean that it didn't happen. And my Lord Justice Snowden absolutely right that in these sorts of areas, if I may say so, it's essential to rely on expert evidence and not to seek to sort of apply some kind of common sense, whatever that might be in this sort of area. That's what I wanted to say really about the gaps in the data. And we'll have to, I'm not going to try to do the carriage dispute now, but as you can see, you can see immediately that it doesn't seem to us to be a point of distinction, an obvious point of distinction in relation to carriage, because after all, everybody's going to need to do their best with the data when it becomes available. Hollington and Hewthorne, if I may.
Yes.
Now, I'm prepared to proceed on the basis that Mr. Kennelly is correct that Lord Hoffman's dictum in Courage and Crean is no longer applicable to this Commission decision because the courts here no longer have a duty of sincere cooperation. I make that I accept that purely for the purposes of this appeal. But so I accept that if we were at trial and we were suing banks other than Credit Suisse, there would at least be a potential issue if we were seeking to rely on reasoned findings in the Commission decision as evidence as against those banks. But that is not what we're doing here. And it's important to appreciate both the stage of the proceedings and the role which we are inviting this Commission decision to have. Now, in Qualcomm, the CAT held, first of all, as you see, the Qualcomm judgment, the CAT held it wasn't bound by Hollington and Hewthorne, but it said it would follow it in that case. And the case actually is quite careful to leave open whether it would be appropriate to apply Hollington in all cases in the CAT. And certainly it doesn't leave open whether it would apply at all stages of proceedings.
Can I ask you to rewind just for a second?
Yes, of course.
What do you actually say, and where is the test in Hollington and Hewthorne? What does it actually say? I mean, what is the actual test that we're all talking about?
Isn't it the test that's that's derived from Lord Justice Christopher Clark's judgment, as set out by Mrs. Justice Bacon? I mean, I took it as that.
Yes.
Certainly.
Yes, that's the model.
Applied that test in other cases.
Yes, that's absolutely right, and that's the modern.
I've temporarily lost the.
Yes.
Page 13 of the judgment of Mr. Justice Bacon.
Yes, that's it's Rogers and Hoyle.
Thank you.
And essentially the test is that it's that I'll try to find the precise.
So I'm just looking.
It's paragraph 39. It's paragraph 39 of Rogers and Hoyle explains the.
Sorry,
forgive me, you don't have Rogers, of course. But I think it is. Yes.
Paragraph 13 of wrong. Decision.
Yes. It's set out in paragraph 13 of the Qualcomm judgment, and it's that is the reasoning of the test, and it really rests on two.
well, okay, but it says that findings of fact made by another decision maker are not to be admitted in the subsequent trial.
Yes.
Can you just flesh it out a bit more? Is this where the same factual issue arises between the same people or what?
Well,
I reformulated, is the decision of the CAT the same as that of the Commission?
I'm not sure that that's
question,
it's.
Because it
normally-
isn't, because Credit Suisse are not a defendant.
Yeah.
Different documents, different evidence, it's just same market, same sort of conduct.
Yes.
In which case, the rule doesn't apply.
Well, the point is, I think it's the one that my Lord Justice Snowden, I think, put it in the course of argument. One has to ask, what are we relying on this for? And the answer is, we're not relying on this decision to say these facts are true in the certification process. We're relying on this to say this is a plausible theory, and no more than that. So we're not relying on it to prove any facts, but we're not relying on those facts for the truth of their contents. And we just observe one point about Qualcomm itself, which is the claimants in that case pleaded reliance on these various decisions. It was a judgment of the US court that was subsequently overturned, and the various Far Eastern regulators. And they did so initially at the certification stage for the purpose of showing that they would be able to get disclosure of documents and information necessary to establish the necessary factual, economic and legal elements of the claim. So at the certification stage, they said we don't rely on them to show correctness. And the court then, in due course, certified the claim in Qualcomm. We don't have the judgment on certification. Oh, I think we do have the judgment on certification, in fact, in the bundle. But it didn't consider it necessary to rely on the foreign judgments in its certification. And then what occurred was this: after certification, the claimant pleaded a reply, and in its reply, it said, at trial, well, I'm not quoting precisely, but essentially it said, at trial, we will be inviting the court to rely on the reasoned findings of the regulators and courts as evidence, not as decisive evidence, but as evidence. And it was at that stage that Qualcomm applied to strike out that one sentence of the court. Now, it was common ground at the hearing that the claimant could rely upon those foreign judgments insofar as they simply recorded the underlying evidence that is mentioned in the judgment. And that is a well-established exception to Hollington and Hewthorne. And there's always a difficult question of where is the precise...
And it's not an exception, it just doesn't fall within the prohibition.
Yes, it doesn't
That's
fall.
why I asked you what actually do you say is the prohibition?
No, exactly. But the underlying evidence is not prohibited. You can refer to that insofar as it's it's a record of fact, a pure record of fact in the judgment. But it is important. But we are, as I said, not relying on these as findings of fact for the truth of their content. We're saying, look at what the Commission has found here. That shows the plausibility, or look at how the Commission, if you like, has approached this. And this shows the plausibility of our theory. It's in the same way that we cite examples of Commission decisions involving information exchanges.
When you say plausibility of the theory,
yes.
What, if I just unpick that rather neat little package, what you're actually saying is the whole question is whether your economic theory is borne out in fact.
Yes.
In this case. What you're saying is, look, there was another case where on different facts, i.e. different communications between traders, a different cartel,
yes,
but of the same type,
yes,
the same theory that we're now propounding was held by a tribunal or a body to have had the factual result that we contend for in this case on our facts.
Yes.
So our theory is not without some prospect of success on our fact. It's not simply
Theory.
yes.
it's not nonsense. It's a theory
Yes,
which has
yeah.
been proved in a different case.
Or, no, one doesn't even need to say
To have
proved.
worked
It's been
in a different-
alleged, if you like, in
Yeah.
a different case by the Commission. I mean, suppose it would be sufficient for our purposes if the Commission, there was no decision, there was just to say a statement of objections by the Commission stating that it alleges these things. That would suffice to corroborate the plausibility of the theory. And that's the only sense in which we seek to rely on it. I mean, one can test it in this way. I mean, suppose you had a decision involving similar but rather more different facts. So suppose it was a metals exchange, and you had recurrent exchanges of information on, and in that scenario, some regulator had held or alleged that this led to an adverse selection effect, which caused prices to increase.
So it's a plausibility of
It's
methodology.
a plausibility of methodology. Yes.
But it can't stand on its own without you also demonstrating that at least there's a sufficient likelihood, if you like, of factual material coming into these proceedings to do the same job that other factual material did in the Snowden ads.
Yes. I think that is reasonable. I mean,
It's two components.
Yes.
One is plausible theory,
Yes,
and second is facts in this case.
yes, indeed. But
And
one,
it goes to the first of those two, not the second.
that's,
I think go to the second.
that's fair.
Sterling was a case in which they applied a theory on the basis of facts that they had in their possession, and they therefore concluded, A, systemically, and or B, in all likelihood, that there were de facto anti-competitive effects which equate to either a gain to a defendant or a detriment to the counterparty.
Yes,
And we look at that and say, Credit Suisse isn't a defendant, it's not the same evidence, it was a chat room, but it's indicative of how your theory might apply to the different facts.
yes. This sort of, as I said, I think at the outset, it's corroborative of in the same way that, say, of Professor Breeden and Professor Rhimes' approach, the same way that an academic article might be corroborative. It carried out a statistical analysis and said, look, this we found an adverse selection effect, and we found losses or profits to the participating dealers that are imposed on the non-participating dealers, and that's as far as it goes. But really, one shouldn't need it, because you've got two professors of FX microstructure telling you that this is
We shouldn't beat
plausible
around the bush.
theory.
It has a different probative value. It is a specialist regulator who's gone through a quasi-criminal procedure, and applying a quasi-criminal burden of proof and standard of proof has come to a conclusion that in a comparable or proximate case, there was an infringement
Well, I
in
see.
which they could establish at least putatively that there were effects.
I see that, but I still say that it's not essential.
It may not
It's
be essential.
desirable.
No,
It's
no,
a
it's
nice
true.
to have, you know. And the I mean, connected to that, I think one needs to. I should come back just to one. Well, let me. I think it's that we should. It's I've gone past the shorter
I
journey.
think it's probably time for a break.
Yes.
Well, how are we doing?
I can actually. I can probably finish the rest of this in 15 minutes. The rest is pretty.
And how long was this week for?
Maybe 45 minutes, hopefully.
Takes us to about 3 o'clock.
Yeah.
And then you've got your internecine warfare, which is going to take longer than an hour and a quarter, isn't it? An hour and a half.
I think
So
realistically,
we are going to go over into tomorrow.
Sorry about that.
Into Monday.
Not Monday. Can't go into Monday. So
Try and do our utmost to be finished.
So
by
we're going to go
lunchtime
over
tomorrow.
into tomorrow, come what may, by the look of it.
We haven't heard from Mr. Robertson yet.
No.
Waiting there.
Best is
Like a
yet to
blushing
come.
bride.
I'm waiting for the hostile beauty parade.
Very, very patient, Mr. Robinson. Okay, well, we can't sit before 10:30 tomorrow, unfortunately. So we will sit 10:30, but this case must be finished before lunch. Must be finished. Yes.
Pretty much rules out costs seem to.
Yes, I think also it probably rules out the costs. I think perhaps you can have a think about that, but I mean, I think we're a bit sceptical that we can fit that in.
Well, for our part, we agree. We agree.
And I think we did indicate that this is something that will be done in 2 weeks' time, and we can probably no, we need to absolutely right. We can slot that in on the Thursday if we like. I mean, at some stage, I quite like the skeleton documents that are said to be in the bundle but aren't. Tabs 33 and 34.
They're not
The
there.
core bundle aren't there. It's tantalising, it says TBC.
Forgive us.
Right, well, 2:05.
All right.